Snow fell cold on a bitter night. John was gone for the morning light. They blame Karen, but it don't sit right. Too many secrets hid from sight. Oh, the badge runs deep, the law runs thin. They stack the deck, but truth won't bend. The judge looks away, the truth gets drowned. Ain't no justice in Canton Town. Proctor's story shifts and sways. Cameras vanish, records fade. The Alberts toast while the doubts grow strong. The folks still fight, won't be long. Oh, the badge runs deep, the law runs thin. They stack the deck, but truth won't bend. The judge looks away, the truth gets drowned. Ain't no justice in Canton Town. Proctor's story shifts and sways. Cameras vanish, records fade. The Alberts toast while the doubts grow strong. But folks still fight, won't be long. Oh, the badge runs deep, the law runs thin. They stack the deck, but truth won't bend. The judge looks away, the truth gets drowned. Ain't no justice in Canton Town.
Morning.
Good morning, genitals. And Dave became a member at one of your channels.
Is that how you just start
mine.
every day? You wake up with the howdy, genitals. How you doing?
Every time genitals is in chat, I'm glad because then I get to say good morning, genitals.
Yes, that is always the best part.
Outstanding. Today's going to be good. I'm excited for today.
Yes.
It's going to be half a day. Bev is going to rule against the defense.
Of course.
And we will have 45 sidebars. And solo Blue Man group is just going to sit there and say, well, if I say it, it's true. I missed that yesterday because I got so mad when he says, well, to an engineering certainty. And when I say that's what happened, it happened. That's the last thing he said where Bev said, and unless he was, ¿Cómo?
Yeah,
¿Cómo?
the more I thought about him cosplaying as John, the more it was so ick.
The whole thing was ick.
The whole thing was a fever dream because I'm trying to explain to the Mr. Mo and the guy who's there to fix our oven, and the guy damn near burnt himself when I got to the blue inning. He was like, "Do what now?" He's like, "Damn, I nearly burned myself."
I have a friend who I work out with, and she's I think it's called recreational therapist or something, who fixes you when you're broken. And so she knows a little about bone structure and stuff like that. I said, if I told you this happened, what would you expect? Well, of course, massive
Bruising.
massive bruising on the arm, and if he was holding at this position, most likely a cracked rib, or at least the entire side would be blue. The hip would most likely be shattered, if not, it would be very damaged because of the way he was standing, and his knee would have, if he was lucky, it'll only tear all the tendons in it, but there would be fractures at ulna. I can't remember the names of bones.
Ulna.
Yeah, but
ulnar radius,
and at the elbow,
And the
and
humerus,
and
I think.
yeah, and she said, and I don't know enough about skulls, but I think that would be a near fatal accident. Then I showed her the pictures of the injuries, and she said, "Oh, that looks kind of like someone tried to cut him, but it didn't get close enough." I said, "Well, yeah, I see a dog." Yeah, well, she has a Staffordshire Bull Terrier, so she said,
Nice.
"That's not how my Bull Terrier's teeth look." Dude, that guy's career is clearly finished, and you went and stole his toupee.
Toupee, I think, is what he's
Well,
meaning to say.
like Donald Trump, it's all real.
One thing that really stood out to me yesterday was he
And I
expressed
will
how
find
like
Jesus when I come to America because Iris is taking me to Taco Bell.
nice. You're gonna be praying to Jesus after that.
I
He
thought
was
most
mentioning
Mexicans
how
was called Jesus.
well, this is Taco Bell. This isn't Mexican food. It's American.
It's Taco
Mexican
Bell.
food.
Iris
Jesus,
have told
not
me you can't
Jesus,
get
Jesus.
anything more Mexican than Taco Bell.
But
Yeah.
right club you can.
I put a camera on so we can see how they react. What happened to
On that
you?
note,
I was
Miss-
struck at. Have you seen those people who did the clips where you can see him roll down to get the paint on his arm? That was
No.
amazing.
Yeah.
One thing he mentioned yesterday was that the spin varied so much depending on what foot was down and which foot had more weight on it and what angle the car took. So how in the world, if it varies so greatly with the spinning of the collision, how did he fall flat back on his head? I don't
Yeah, that's-
understand how
that's-
those two converge into one.
Again,
just
if it
doesn't make
was a
sense.
wrestling match, I could because they do it to make it. Mo, it was a joke because they wanted you
Oh,
to be.
it's a dress, y'all. I am fully clothed. I promise.
I dig it.
Oh, I get it. Never mind. It's been a long look. I was up making soup for Mr. Mo this morning at 4 a.m.
Nice.
Rianne, don't waste your time. It was just more of, hey, I said it. Did you test it? I said I looked at it, and I listened to an interview with her, so it's science-y.
Ish.
That was horrendous. What did you base it on? Well, I did some testing, and then I watched an interview with her and read a police report.
That was
Yeah.
almost as bad as the Johnny Depp being judged from his acting. That Dr.
Yeah.
Spiegel or whatever the hell that guy's name was. Well, I watched his
Yeah.
roles in The Mad Hatter, and clearly he's off his rocker.
Yeah, that explains a whole hell of a lot. And also, he didn't do his own independent investigation. Whatever he said, he took everything from the state's point of view. And while I didn't get to hammer him as much as I think they should have about his communications, I think it is clearly evident that Brennan knew that the report from Shannon with one N was coming in. He knew that the Tokyo time drift was coming into this too. So it's really, really disingenuous for, I'm sure Brennan's going to come up and say, this is trial by ambush. I am being ambushed.
Even though his expert changed the report the day before or whatever the hell it was.
Yeah, pretty much. I mean,
He's
Good
a
try.
disgusting human.
Gå efter med dig.
bacon French onion, actually.
Clam chowder.
I don't like clams are gross. Sorry.
Clams.
Ugh.
Bite your tongue.
They are.
Okay.
Clam chowder is delicious.
Smells like clam. Can't help it. Mr. Mo loves it. I'm like, ugh.
Well, most men are a little bit partial to the smell of clam.
I
I would actually prefer no smell of clam. I have been at a music festival where you stayed there for like a week and slept in a tent and toilets. Who needs toilets?
Oh.
You can just
Oh,
pee
God,
on the other
Baker,
guy's
why?
tent. And if you get lucky Saturday night before you go home on Sundays,
Oof.
You think of
why
the
I
queen and you just go in.
That's why I can't do historical romances. No deodorant.
So I
No,
guess
they
Turtle
get to
Boy
the
is like.
smexy part. I'm like, ooh.
I guess Turtle Boy is like on the list today. He's like one behind the cutoff. So if like one person doesn't show up, he gets to come into court today.
Oh, cool. Yeah,
Yes.
and people do look weird at me when I speak Danish. They don't understand that it's a superior language.
Okay.
Dave, no, the expert sent me a clip about a Swedish girl talking about Midsummer, and he said, "Oh, I like Sweden because she was a cute girl, but there's no burning of witches in Sweden. We burn witches for Midsummer, so again, clearly a superior country."
No
Maybe
one
Sweden
expects the
burned all their
Danish
witches already.
Inquisition.
No, I've met Pernilla.
Maybe they're just ahead of you guys.
I met Pernilla.
That's funny.
What?
That's funny.
New motion. Both the Commonwealth and defense are bound by Rule 14 obligation. During the course of this trial, notably during Shannon Burgess' testimony, defense presented documents that was not previously provided, which eliminated the ability to review and vet the documents. Notably, the defense prevented a CV provided in 2023 that noted a graduation date of 2024. The effort of providing documents as a witness is being confronted with documents is improper trial by ambush, a violation of Rule 14, and create needless delay resulting in objections, unnecessary sidebars, and a waste of time for the jury. The Commonwealth seeks a ruling precluding the use of any materials that were not noticed by the defense other than materials in the witness CV referring to during presentation or discussed during testimony. So they can lie on their CV, and if
You can't call them out on it.
and you can't call them out on it. Hanky
Interesting.
panky, you morons.
How does that even make sense? Like, if a man presents his
Yeah.
CV in expert testimony, and then they have another record, like, how are they supposed to know to turn that in? Like, that's the stupidest motion I think I've
Not to
heard all trial.
mention, you are allowed
I
to
didn't know your
find-
guy was gonna lie. My bad.
Aren't you allowed to find sort of impeachable evidence? Even it's
That's
from a
the
federal
whole thing
court.
with cross-examination is to impeach him.
It's not like they went to his Yelp reviews and contacted, Billy the Booger 2000 and said, "Hey, by the way, how was he?" No, they went to federal effing court. I mean, again, I have never in my life seen a bigger cry bully than Hank Brennan.
There's another motion filed, a trial memorandum on experts' opinions, where he summarized, says, well, because it's within his field, he can say whatever he wants.
No.
So, yeah, well,
No. According to that guy, everything's in his field.
Yeah, he is the science. Also,
I did
Can I,
see that
so,
he's
sorry,
got-
sorry, can I read this?
Sure.
The defense cited Commonwealth v. Coleman without providing a copy of the case or a summary. Citing a case name doesn't make the case relevant or applicable. In Coleman, the medical examiner testified that in his opinion, the cause of death was homicide. The court referenced Commonwealth v. Lannon, opining the better course was to exclude some opinion testimony, but here it was innocuous. In the Lannon case, accident was offered as a defense and homicide could be taken in to contradict that defense theory. Here, homicide does not seem to have such a contradictory implication as to the defense theory of self-defense, i.e. justified homicide. This is what they're leaning on. The medical examiner went into detail about the autopsy procedure he had followed to reach a conclusion of death by gunshot wound of the chest, massive hemorrhage, and homicide, and the jury could not have imagined he was expressing an expert opinion on how the shot came to be fired as opposed to the results of the shot. Based on the data, physical evidence, and expertise of Dr. Welcher, it is his opinion to a reasonable degree of scientific and engineering certainty that there was a collision between the defendant's SUV and John O'Keefe that occurred around the time of the defendant backing maneuver in front of Fairview. How did he reach that? Because he didn't say. He just said, "Yeah, it was there."
Yeah, at some point during this backup stage, she had to have hit him because we found it. So that's.
I can't prove it because there's too many variables, but it happened.
Trust me, bro. I did see something where he's
Thank you, Marissa.
This guy Judd Welcher's got some appeal in California over something similar.
No, he has another case in Massachusetts where he was barred from testifying using kind of the same techniques like he's using here, just dropping test dummies. But there was 4 different cases mentioned, and one of them I think could kind of be applicable, but it's the YouTube, it's the Twitch thread. So people say, "Oh, he was barred, so he can never ever testify." That's not what it says. It said it was not applicable in that case. So
no, I saw something in California where he was doing like this, where he wasn't using the actual car in question. He was using photographs of the car and claimed that they were exact replicas of the actual car, and somebody else was like, "No, this isn't the same thing." And now it's an issue.
Let's
Good morning, everybody. All right, so Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied.
I don't think so.
In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus. Because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application. However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology.
This is actually correct. This is what an expert is allowed to do.
The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So,
and everyone who is yelling right now, this is exactly correct. He is allowed to say that based on his opinion and his expertise, he could have been struck by a Lexus of that make and model. He is not allowed to say Karen Reed did it. But
you know what, though?
Then he is open for cross-examination where they can then attack his methodology. So this is actually the correct ruling. What the defense didn't want yesterday was him stating Karen Reed killed John O'Keefe, because that's for the jury to find out. This is a correct ruling.
This was.
Go ahead, Val.
This was something that I was wondering about yesterday, right? If he's not allowed to say that it's consistent with this accident, blah, 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 neither would the defense witnesses, right? So now that this is here in the way it should be, every defense witness that gets called is going to be able to say, no, this didn't happen. Yes, this is from a dog bite, et cetera, et cetera, et cetera. Yeah.
And Kiwi Green, you get allowed to be an expert in every single case. It's not you are barred forever because you got kicked out of one case. It's not automatically you can never, ever testify in Massachusetts again. I've seen the same reports. It's Twit. Don't believe everything you read on Twitter. He was barred in one trial because they didn't find his methodology credible. That's up to Alessi because Bev have said we don't need a voir dire. Bev has accepted him as an expert. You can't get barred just because you got kicked out of another case. He will then have to be wadered or be told. The judge will have to say, "Hey, yes or no, can he testify?" So again, don't believe everything everyone writes on Twitter, because not everyone really reads it. They just say, "Oh, so he can't testify ever again." He had exactly the same thing happen to him that happened to Miss Hyde. It was tossed out. I think it was a civil suit, but it's not an automatic ban from ever testifying again. It's just that his methodology isn't legitimate, and unless he can use it to attack him later.
The one
That's-
thing
And this
that
is
I
in line with what
the one thing
most
that-
experts testify. It's consistent with, they don't ever say this exactly happened. They say, for the most part, this is consistent with, or it is not consistent with. They never make these kind of point blank statements like he was trying to make. Karen hit him with the car.
Yeah.
We don't know when.
Yeah.
So that was what was improper. And now Bev is sort of leveling that. And I hope she tells the jurors to strike that comment, even though
She
it's
did
already,
that yesterday already.
but
We
it's,
ended with a
it's already
stricken
out of the
comment
bag.
yesterday.
All right, so the jurors are lining up. We should have them momentarily, or right around. Why don't
But I feel as though there is one slide, so I'll admit it conditional to redactions that you didn't rule on, but I feel as though you probably will exclude, and that is in that version. I didn't want to pull it out with the court's order, but I'll talk to.
do you know the number? You don't have to find it if you don't.
131.
Oh, was it 130? Was it 131 yesterday too?
It was.
So at sidebar, I said we could go back to that, and Mr. Lessie agreed that we could go back to that. So, and I know I thought we were starting there, and I think Dr. Welcher thought we were starting there, and then you went to 132. That was my understanding at sidebar.
It is, but subject to me being able to object. I was basically, because we wanted the jury to come in, so I want to look at the slide.
Okay, so look at it again. That's not my understanding, Mr. Lessie. It was you were concerned just about the heading, and then I said we'd go back to both slides.
Oh, yeah, no, I'm okay with that.
Yeah.
That one, yes, your honor recollection is correct.
Yeah, and-
I was okay with the heading.
And we were going to start on that, but you thought because I struck it based on the objection, but then at sidebar, I said we could go back to that. That's your understanding too.
Correct, Your Honor. And I'm sure that Dr. Welch took off the heading on 131.
I think he did, but because I think he took off from 124 to 1.
I think he did as well.
I did.
Thank you very much.
Okay.
I would like your prediction to come true.
Are they out there, Paul? Okay, thank you.
How many more slides of death are they going to show us?
all of them.
I just loved it yesterday when
Do I need it? Give your attendance.
there's a slide missing, and he starts skipping. I would just have said fuck and just moved on.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left? Everyone said no. Thank you.
I have.
I do it all the time.
Yeah.
Morning, Dr. Welcher.
Good morning.
When we left off yesterday, I was asking you about some of your opinions. I'm going to ask you those questions again, but before we do, I'm going to ask you two other questions. The first is, I'd ask you to turn to your PowerPoint, slide 110.
Oh, that's 144 pages. We're only on 110.
Yep.
You want me to display it?
Please. I'm going to ask you a question about a series of your slides regarding this effort. This is 110. Could you also follow through to 111, 12, 13, 14, 15?
You want me to play the videos?
You don't need to play the videos. I just want to acquaint you for the question.
111,
12.
112, 113,
Oh God, he's
Oh,
bringing it up again.
114.
Why?
115.
How many times did you engage
I
in
don't know.
testing where your arm and forearm touched the rear right of the exemplar Lexus?
3 times.
In any of those 3 times,
3 times.
did it ever leave any paint on the underside of your arm or forearm?
No.
If you
That's
could
it.
turn
Case
to
over. That
slide
proves it.
130, please. What? Could you go back one, please? Perhaps it's
Man, I really wish I knew what you were saying, Baker.
Baker, you're muted. You continue to be muted.
Hey, I'm
There you go.
talking.
There you
I'm
go.
talking here. I'm really saying something interesting, but now I'll just dumb it down because you didn't hear it.
Thanks.
Marissa found this one where it says, this is how it should have looked if it was a side swipe by a car in the position they set, because the arm would fold over and follow the car, and it would go down his arm.
Question: if his arm had been, you know how when Val stood up and had it more at a relaxed angle,
Yeah.
those
Then,
would be.
then it would hit his elbow area and throw it
Yeah,
this
look,
way.
I'm just trying to play devil's advocate, but those look like Friberto bite marks to me.
Yeah, you
There's no
can't
way
get
a
can't get it that way.
6,000-pound vehicle hits your arm only, right? Like, there's no way that you can only get scratches here without blasting you in the ribs, without it's just it's inconceivable.
This arm is so weird. It's got a very foreshortened upper part and then a very long lower part. So even if they try to do it perspective, he's got like a very small bicep and delt, and then like the longest
John
forearm
Arnold
ever.
shows he got
it's like-
the
it's
pointy
angled in
biceps.
like this. It's just angled in a little bit. That's
Yeah,
it.
it's
That's
because it's in this position, so it looks
Well,
weird.
we can all agree
Unless
he's
he's
more
our-
buff than not dead John.
131.
The guy who
Thank you,
dressed
Marissa.
up as him, cosplay.
Oh,
Could you explain the sequence of this slide, please?
Judson,
Judson.
Could you take that down?
Blair,
Dr. Welch?
Judson, Blair Welcher.
We're going to move forward.
That kid did not have an easy time in middle
Yesterday,
school.
when we left off, I had asked you,
So we need to take this.
you can take the PowerPoint down, please.
That was in a different spot on this line. Hold on a second.
Yes, I've said that a million times as well, Sandra. Where was his phone?
Thank you.
It must have been
Sir,
in
I
his
had
right
asked you
hand.
yesterday about some of your opinions. I
Correct.
want to ask you about some of your opinions relative to that last effort that you made regarding testing between the Lexus and your arm.
Correct.
You had mentioned earlier on in your testimony that you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Relative to the testing on the arm contact on the taillight.
Yes.
So it was the physical evidence at the scene, the photographs of Miss Reed's vehicle, to a certain extent, my analysis of the Ring doorbell and the One Meadows event, the nature and
Your Honor, pardon my interruption. I just want to know if you something or not.
Looks like he's counting on his reading from
no, I am counting on my finger.
Okay, thank you.
So I am counting my fingers. The Ring video doorbell, Mr. O'Keefe's height, the type of shoes he's wearing because I need the same type of shoes. My exemplar inspection where I matched up the heights.
Why did that's another thing that bugged me yesterday. One of the things that it's very Valhalla and I are roughly the same height. It's within millimeters of the same height. I weigh twice what Valhalla weighs, and I'm a little bit wider. If I stood in Valhalla's clothes and said it would be the same, it wouldn't be correct. I weighed around the same. There's a very big difference if you are like Valhalla, you are a built man, or you're a fat guy like me. It's very different what would happen to a body at that impact. How long was his arm? Did you measure his arm, or did you just say my arm is the same length? Because we can do the hand test and see everyone has different size hands as well, even though we are exactly the same size. This is all the make it of believings. And by the way, I did this measuring this morning. The green X's is the optimal braking zone that she would have had to before she could come to a rest. So that's past the driveway. The first
Well,
four
and
X's
here-
would been a white Jeep with a plow on it that she didn't hit.
Uh-huh.
Well, not to mention this. Okay, him getting the same shoes. This is a microcosm of why this is so wrong. This is not science. You don't just approximate. His center of gravity is going to be different. He's obviously not, as physically active as John was. None of this is science. This is science-ish. This is like, I watched a couple Magic School Bus episodes and some Mythbusters, and I'm a scientist. This is not how any of this works.
Yeah.
Locations of the lacerations, and then the tech stream data as well.
That information that you considered, in addition to the text stream data you considered, considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in whether the
That term still bugs me.
damage
Yeah.
to
Yeah, it's a weird
the defendant's Lexus is
I don't think
consistent with
they're allowed to say
the collision
scientific certainty with
Mr.
this guy.
John O'Keefe on
Otherwise, he
January
would've.
29th, 2022 at around 12:32 a.m.
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
Do you have an opinion whether, based on the data,
Where'd you get this
and based on
information?
the
He made it up.
So
Trust me,
every
bro.
single
8
car
miles?
that gets rear-ended at slightly more than walking speed will have busted taillights. Okay.
Somehow I don't think
damage
the
in
safety
your
inspectors
testing,
for cars
whether
would
that
let
is
that
consistent
happen.
with a collision or a impact with Mr. John O'Keefe?
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Yes,
What's your opinion?
that it is. It is
How?
consistent with being struck by a Lexus.
How?
Unless
And
he's
ultimate
gonna
contact
tear
is
this dude
hard
up.
surface such as
Oh,
ground.
And
Yes,
that's specifically
anything greater than
pertaining
8
to
miles per
January
hour will shatter a
29,
taillight.
2022 around 12:30 a.m.?
I think I can punch a taillight with 8 miles per hour.
Yes, it does.
oh, guaranteed, guaranteed.
I had a headlight gone out the other day on my car,
finish, I'd like to
and I
ask
went
you a
out
few more questions.
and doinked it a couple
You've
of
written some
times just to
papers
see if it
on
was a
Sideswipe collisions
didn't bust.
or clipping. Can you
See if it would
describe
just
to the
shatter
jury and
into a
explain
million pieces.
what a sideswipe collision is or a clipping and how that may or may not differ from a direct hit on a pedestrian impact?
Sure.
This case brings new meanings to the term snow job. I think the term is blow job.
So what generally
Thank you, Stacey.
differentiates, say, side swipes or clipping contacts compared to, say, an inline impact or, say, a T-bone impact is what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate. And so in a glancing hit, you can have a glancing hit and you don't have what's called complete momentum transfer, meaning the momentum from the car, because it's a glancing hit, doesn't completely transfer to the object being struck. For example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going because you don't have all that momentum transfer. So when you have glancing contacts, you can have much higher.
To all of us who use real numbers, 8 miles per hour is 12 kilometers. So that's a good running speed if you are a good runner. That's a high running speed, but still, it's that's. I think if you put your car in drive and just let go of the
Break.
brake, it'll probably get to like 5 miles an hour easy. So it's a little more than idling in a car.
I wonder how fast she was going when she backed out of the driveway and hit John's SUV.
These are probably they didn't say it. I think 3.6 miles per hour or something like that. Yeah, he got hit, then hit his head on the ground. Yes, because he got hit in the face with the car. Remember, he said that yesterday.
Alessi will be like, hold my beer. Lol. Agreed. Alessi's going to eat this dude's lunch.
I hope so.
Higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing
Thank you, M-Spy.
type hit.
You mentioned about potential damage to a car. How about potential damage to the pedestrian?
It's the same thing. So when you have a glancing hit to a pedestrian, this is referred to as a fender vault. In this case, they call it a fender. Fenders on the front of cars because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted without a whole bunch of information in that type of crash. If the impact had occurred in the center of the vehicle and we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle is going. But when you have just
But you do have the speed bozo.
Yeah.
You're relying on the tech stream data. So you just do a backwards calculation because you know the velocity of the car, you know the speed of the car, you know the resting place of the body. And then you can just calculate it.
a corner clipping or glancing, it makes it more difficult to determine, even when you have an area of impact, which is where the person was when they got hit, and a point of rest where they landed, makes it more difficult for glancing contacts because you have that side swipe problem where they don't obtain what's called common velocity.
And what are some of the other difficulties in attaining specificity in a side swipe or being hit by a quarter panel as opposed to a fender?
So for a pedestrian, correct?
Yes.
So pedestrian impacts and how you move post-impact are very sensitive to your exact body position. For example, whether your right foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply raising and lowering your arm changes the amount of rotation that's going to happen.
Then
Post-impact
how did
motion
you get to the point
of
where
the
you
person.
could drop a crash test dummy straight backwards and claim that that is enough medical testing? Like, how did you get to that point, sir? If you're saying that no matter what position he's in, it's going to change the velocity, spin, momentum, force, etc., then how can you just drop a crash test dummy backwards and call that scientific methodology?
Again, impact sends him spinning in some direction. But he wants you to tell, even though he's spinning, at some point he just does a dead stop and falls directly backwards. He would be tumbling.
He's proving that his own methodology is garbage. That's what he's doing. He's testifying that his own methodology for finding out the injury to the back of the skull is absolute garbage science.
Brendan will be doing a test with a homeless person in the first break. Just keep it under 8 miles per hour. No accidents happen at less than 8 miles per hour.
Ugh.
And this guy has an extra Lexus. I bet you he's driving it.
I guarantee.
So cadavers, crash dummies don't have any muscle reaction. So the motion of a crash dummy is just going to be like you're hitting a dead body, to where people will step, try and regain their balance if possible, will do additional activities that alters where they come to rest.
In your studies of direct pedestrian collisions by front or back bumper, as opposed to side swipe or clipping somebody, is there a similarity or difference in type of injuries that you see?
Yes.
And what is the difference?
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's
You can kill
more,
people at 8 miles
you're
per hour.
accelerating the person up to the vehicle. They can wrap onto the side in front of the vehicle at higher severities. Their head will hit the hood, their head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred to the actual occupant. There's more applied force to the occupant as well.
When you see direct impacts, is there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the Accident Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures. It depended on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian accidents to see no lower body broken bone?
No, it's not uncommon.
have you had cases that you've studied or been involved with where you've studied the effect of a side swipe or a clipping impact where there's an absence of broken bones in the lower body extremities?
Yes.
I'd ask you to turn to slide 139, please.
Oh, sorry. I fixed those other two slides.
Okay. Could you share with the jury what this
fixed.
represents?
Sure. So this was a trial that I was involved with in downtown Los Angeles. I've redacted the name at the top, but this was an instance where we had, this is a image from the police report. Oh, let me see if I can. So AOI in this diagram stands for area of impact. That's where the pedestrian was when they got hit. AOR is area of rest. And you can see we have information on exactly how far the pedestrian was thrown. Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact. And then what you see is a close-up on the bottom slide of where there was DNA transfers, hair and tissue samples on the
Oh, so
vehicle
blood
from
transfer?
the individual that was hit by the vehicle.
Hair and tissue?
Next slide, please.
Holy crap.
So, I'm going to take this down.
Yeah.
That's not a nice picture, but I can go back to the other one.
Where there was
I'm just going to show you. This is first of all, this is half the height of the car.
Lower center of gravity.
Lower center of gravity, and he gets clipped by the car here. Look at all the damage it does to the hood and the quarter panel, and
Cripples it.
to the front. I don't know what that is. This is called, but
And I don't even know. It's above the bumper.
yeah, all of this is destroyed. And again, he says the scrapings on the rear fender is the same as Karen's SUVs. But am I seeing it wrong, or the headlight isn't broken?
I can't tell.
No, it's hard to tell,
Maybe
but
broken.
again, this entire headlight, because this happened at 25, 35 miles per hour, this entire headlight should have been absolutely crashed because lights on a car brakes at 8 miles per hour. We just learned this. But absolutely the same. You can see how low the front of the car is if you see there's a sedan parked next to it. This is half the height of Karen's car. It'll give you a totally different result because this guy would be slamming onto the hood and then get thrown off, where he would be more pushed by the back of a Lexus. But I'm going to take us up on the big screen and then start this again because
That's an amazing demonstrative there, Aperture. You should probably show those photographs in every trial that you're a part of.
especially the part where it looks like his arm is ripped open.
Yeah.
he was killed at the scene. What you see on the left-hand image, on the left-hand image is he had a
Now he's zooming in on the hole in his arm. But again,
Awesome.
this is the same impact speed. This guy was killed at the
25 to 35, they said.
but that's
Miles per hour.
that he doesn't know the speed John got hit with, but it was around
Correct.
24 miles per hour.
Correct.
massive laceration to his right forearm, but it didn't break
You
his arm.
notice how it basically
There were
ripped
no
his
broken
arm
bones
off,
in his
though?
arm.
Yep.
On the right-hand
I'm
side of
looking
this
at it.
image, you see the autopsy report. What you'll notice is he had red marks on his leg, left buttocks, but he had no leg fractures. And again, this individual was hit at between 25 to 35
But he also had lacerations to his spleen.
miles an hour. Yes, yes, sure.
Do you want that expanded by 2 times?
There you go.
Thank you. Sorry.
Yeah, no, my pleasure. Ron, thank you. So
I'm not going to show people who are
top.
dead.
he had a severe brain injury, which again is the most common injury in pedestrian crashes. He did have fractures of the right 11th and 12th rib and a liver laceration. If you look at the extremities, it says right upper extremity. Again, that's from the shoulder to the end of the hand. Extremity wound with vascular injury. So no fractures. If you look where I was talking about the multiple abrasions, so when they're looking at the lower extremities,
Let's just look at it. Right
Look at all
subdermal
the
hematoma,
injuries. Look at all the injuries.
subarachnoid hemorrhage, interventricular hemorrhage, fractures of right posterior ribs 11 and 12, bilateral hemothorax, pneumothorax, liver lacerations, right upper extremity wound with vascular injuries. Yeah, it tore his blood vessel, his blood. The system,
Artery, arm,
his arteries are open. Multiple abrasions: right knee, left anterior leg, lower back, right lower back, left buttocks, posterior right leg, right ankle, which is exactly aligned with what we saw on John O'Keefe. Scratches to his arm and a cigar-sized red mark to his knee.
And look at some of these bruisings. 12.5 by 6.5 inches, 8.5 by 5 inches, 9 inches.
I don't know what that is.
They're huge.
Guessing.
It's huge bruises, like bigger than your hand, right? Like way bigger than your hand. It's like a dinner-sized plate. Some of those
Punctures lungs, both of them. Yeah, but it's actually exactly the same that happened in this case.
they're noting a number of red marks, but there was notably no fractures to the lower extremities.
No, but there was a whole heck of a lot of injuries to his upper body. Oh my God!
Dr. Welch, regarding your analysis of the data and the evidence in this case,
sir,
do you
those
have an
two
opinion to a reasonable
incidents
degree
are
of
not the
engineering
same.
certainty whether the absence of lower body breaks to Mr. O'Keefe is consistent with the defendant's Lexus
No, that's his tramp stamp.
impacting in a side swipe or a clipping Mr. O'Keefe?
Yes, you could definitely have this
He's just
type of
gonna make him
impact
say
and not
that
have
a bunch.
anything beyond, say, red marks to the lower extremity.
Thank you, Dr. Welcher.
My
Your Honor,
pleasure.
I would move the evidence subject to redaction.
My pleasure.
Dr. Welcher's PowerPoint presentation.
That's by agreement, Mr. Wilson.
Your Honor, thank you.
Oh,
It's Alessi, the master of the mind game. Whispers your downfall, you don't even know his name. Silk tongue, steel trap, every word a blade. The sweet talk, you're writing to your grave. Call deadly, A-L-E-S-S-I. Just weapon, pays the decree. Sweet word, sharp turn, now you're down on the floor. Brain buster hits and you ain't getting up no more. Call deadly, A-L-E-S-S-I. Logic's his weapon, pain's the decree. Sweet word, sharp turn, now you're down on the floor. Brain buster hits and you ain't getting up no more. He don't yell, he persuades. He don't fight, he invades. Step in the ring and you'll understand. This ain't brawn, this is chess, play my hand. Call deadly, A-L-E-S-S-I. Young logic like TNT. He'll outthink, out of the making regret. One brain buster later and you're losing that bet. Courtesy of a lesson.
one of these things are not like the other. Lol. Couldn't agree more. I'm Spire. I couldn't agree more.
Let's get hopefully a great afternoon. Well, for you, morning.
It's almost afternoon. It's almost 11 o'clock.
Put in both the flash drive and the notebook.
Representation is consistent with the same side.
So let's put them both together now and decide later. Okay.
Those two slides for interactive.
Okay, so we'll switch that. Thank you. What exhibit number is it? 206, thank you.
This is 206 A and B.
Get up there.
All right, Mr. Leslie, whenever you're ready. Sure.
They were just discussing if they would allow his report on that in the videos was most likely on a flash drive, and Alessi said, let's talk about it later. Yes, this can be make or break. If Bev allows him to treat him like she allowed him to treat Burgess, this will be an absolute bloodbath. Hank will be screaming objection all the time, demanding sidebars. But if she hampers him, even though she said you will have a vigorous cross, then it can be really bad. You know, it looks like he's a cat who got some cream. Yes, it would be a direct response to this, more or less. Get your popcorn ready. Here comes Alessi. Thank you, Stringer Bell.
Morning, Dr. Welter.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Lessie. Nice to
You
meet
will
you.
know this by the end of the day, mister.
Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in, giving scientific evidence in court applies to forensics. So my main job is action reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court. When it goes to court,
Tail light breaks at anything above 8 miles per hour, and a guy who was instantly unalived with multiple internal damage is exactly the same as what happened to John O'Keefe. Boom, that's the morning.
that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for law, correct? Would you agree with that? It's for law.
If I were in a dollar store, balls drunk, stoned, and ate mushroom edible like pixie sticks, I would not even buy that tie.
Forensics.
I mean, exactly the way
Thank
you
you,
asked that.
Brendan.
No, it's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking.
That's exactly it.
Okay,
Yeah.
yeah, certainly for the court of law.
It
Yes.
ends up to a court of law, and in forensics is a common term.
Yes, sir.
So it relates to, or it's used in, or it's suitable for a court of law, the analysis. You'd agree with that? It's a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in here in a criminal matter, correct?
Yeah, you try and apply as much as possible.
Right. And so the primary goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information for forensics in a court of law?
Certainly objective information, truth sometimes, again, can be subjective.
Oh, so you don't believe truth? You believe sometimes truth applies and sometimes it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to your direct examination that you just went through.
Please.
Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty. Is that correct?
Correct.
You've also, have you used the word sometimes to reasonable degree of scientific certainty?
I might have.
Right. So
I don't know.
in terms of your role as a biomechanical engineer and accident reconstructionist, is it important?
No, they're actually not paying that much. You can find the billing out there. I think Burgess got $425 an hour, which is low for an expert. This guy's getting $700 an hour.
to engage in a critical analysis of the data?
Critical analysis, yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your conclusions early on in your direct testimony and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
I did.
And that you, quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That is
correct?
100% correct.
Now you simply follow the data. Is that correct?
I try to do that.
You try to do that.
Not perfect. So
Okay.
I do my best. I believe I've done it here.
Okay. So in terms of you've agreed that you apply the scientific method. So I want to see if you're in agreement generally so the jury can understand what the scientific method is. Are you familiar with NIST, National Institute?
Yes.
Yeah. So would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem, the collection of data through observation and experimentation, analysis of the data, the formulation, evaluation, and testing of hypotheses, and where possible, the selection of a final hypothesis. Is that a general fair statement of the scientific method?
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial or things are in evidence. So frequently there's one or two versions and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what I stated relative to NIST, you would agree that evaluation and testing of hypotheses and where possible, the selection of a final hypothesis is the scientific method, correct?
Generally, yes.
Is it correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer-reviewed and a publication that's been generally accepted in the engineering community?
Well, I can't. So this, I've done my analysis here, biomechanical analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to submit my analysis for peer review. So this occurs forensics all the time. The forensic analysis in court generally never goes under a peer review process. The methodologies underneath it and looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science, 26.
So I think you may have misunderstood my question.
Yeah, I think
was
you
talking
misunderstood.
about your methodology,
Mhm.
your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no way of publishing this analysis.
I'm
So
sorry, sir,
to
to
get
interrupt
peer,
you.
I need to,
Go ahead and answer your question.
you're asked peer review, like you said, means I give it to my peers. I send it out to somebody to review.
No,
for the
your
scientific method.
methodology,
That's what the
not
peer
your
review process
paper.
is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir, my question is
Mhm.
not your analysis here in this case.
Oh.
My question regards the methodology that you used here. Is the methodology, you said 26 references, right? My question is simply, is the methodology that you used for your analysis in this matter, is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
I think with the forensic application, yes.
Okay, that was my question, just the methodology. Thank you.
You're welcome.
That was a long waste of time for not
Now,
answering a
the
question.
scientific method that you've used in this case, part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method is to avoid biases?
The purpose of the scientific method is to get the most logical and correct answer without bias.
Exactly. To do it apply the scientific method without bias being part of the application of the method, correct?
That's hopefully what you can do.
That's hopefully what you can do. That is the goal, right?
That is one of many goals, yes.
So are you familiar with the term confirmation bias?
I am.
And that relates, confirmation bias is part of a larger term. Are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, biases are, don't you agree that cognitive biases are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies, engineers doing studies, and other scientists doing studies?
So I'm not a cognitive expert. I think I would generally agree with it, but I don't want to step out of my lane. I'm not an expert on cognitive. I can talk to you about confirmational bias, if you
Sure.
like.
Let's talk about confirmation bias. Now, confirmation bias is actually when someone selectively gathers and interprets evidence to confirm one or another's beliefs, as well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct, what
Generally, yes.
confirmation bias is. And an example of confirmation bias is not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be yes.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So is failure analysis the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences? Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury is, how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you.
So hold on a second.
Okay, I'm
Generally,
sorry.
what you want to do is gather data. You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen? So that's the end.
I think you may have misunderstood my question. So I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in the process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. One of the first questions is, where's the damage? What are the injuries? What's the evidence? What black box or tech stream data do we have? What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Isn't every one of the questions that you just mentioned part of the data gathering?
Yeah.
Correct. But,
Okay.
but when you're gathering data, you're always asking yourself questions along the way, like, what is this? Where did it come from?
But you would agree that for you, at least some point, it's how did this happen, correct?
Yes.
And don't you ask that question to come up with hypotheses?
I generally have many working hypotheses as I'm working on the case. And then
How do you get to those hypotheses if you don't ask yourself, how could this have happened? You don't just open up a binder and it says, hey, maybe it was the rock rats who did it. Oh, let me test rock rats. You make a hypothesis and then you try to prove it.
as
Jesus.
the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the factual information.
Sir, how then is it just a matter of logic or a syllogism? If you don't ask the question, how did this happen until the end, how do you then not get your hypotheses up front when under the scientific method, you should be having different hypotheses up front? How is it that you ask the how did it happen at the end and not go through hypotheses in the beginning? Can you help me with that logic?
Sure, I guess I misunderstood. Like, I was trying to give you an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, you want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along, to be able to answer that final question, how did it happen? But along the way, like, for example, a right eye laceration, you want to know how that happened. So you look for the evidence of how that may have happened.
So you would agree then that questions of how it happened, formulating and identifying hypotheses, does and can happen toward the beginning of the analysis. It doesn't happen at the end all the time. Would you agree with that?
So the ultimate question of how did it happen happens at the end. The questions about the elements of what occurred to make it happen, those occur at the beginning, middle, all along the way.
You would agree that creating hypotheses occurs more toward the beginning than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning, but I am continually forming, looking at hypotheses, either accepting or rejecting them upon the evidence.
So you would agree that the creation of hypotheses does occur more toward the beginning of the analysis. You would agree with that?
There are more towards the beginning. The process occurs throughout the whole investigation.
Right. I'm asking about the hypotheses, sir.
Stacey, I totally agree. This is Jed McCabe in a suit. Just, you're asking me a very simple question that I absolutely don't understand. I'll try and model it up so the jury thinks I was asked a different question, and I'll then say you're wrong.
You would agree that the hypotheses occur more toward the beginning than the end, just the hypotheses.
So I don't know if you and I are saying different things. More hypotheses in the beginning, because you have more questions in the beginning. You continue to form hypotheses as the data presents itself. So you don't stop the formation of hypotheses. It's just as you get more evidence, you window down the number of questions.
Maybe I can just this last question to make it clear for you, sir. You would agree, not analysis, which you added, as I heard it to the last part, just hypotheses.
Mm-hmm.
You would agree that even though hypotheses can be created and changed, perhaps all the way up to the end,
Mm-hmm.
you would agree that it's important in the analysis to create at least some hypotheses, plural, in the beginning, correct?
Yes.
And once you create these hypotheses, would you agree that those hypotheses should be tested?
Obscure Destinations Outdoors. I don't know if it's Mo or Valhalla's channel. Thank you so much for supporting them, and hope you have a great day as well. And Brandon, how are you going to test something without a hypothesis? We are just going into Diddy's house blindfolded now. Look at Justin Bieber, sir. Yeah, he looks horrible. I don't know what, but I'm not having what he's smoking. But yeah, well, I have a lot of hypotheses, but I don't have them, and I have them, and it depends on at what time of the day you ask me. This is clearly a defense dementia witness.
They all are.
So if you take the word testing to mean testing compared to testimony, compared to physical evidence, yes.
And when you test those hypotheses, isn't it often the case that, particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
I guess it depends on the scientific evidence behind it. Again, sometimes we get very unique injuries.
So my question, sir, is this.
Mm-hmm.
Isn't it the case that when you have multiple hypotheses,
Well, hypotheses.
the one that most, out of all of them, it's a relative thing, the one that most consistently produces the same injury emerges as the mechanism?
Unless he mentioned to Bev again that this guy needs to stop looking at his report.
of injury.
I would.
Is that a fair statement?
I think generally, again, it's on a case-by-case basis.
What are
You have
is
to
he
look at the
doodling?
science and
What are
the
you
facts of
doing?
what you're basing it
I
upon.
don't know.
I think as a general premise, what you're saying is accurate,
Okay, that
but there's exceptions.
fair enough. But it's a general principle
Sure.
with some
He
exceptions.
said
That's a fair statement,
generally.
correct?
Yes, sir.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clearer is I'm going to say when I'm switching topics.
Oh, good.
So what I'd like to do now is switch topics.
Okay.
You're aware that the Massachusetts State Police has troopers who specialize in accident reconstruction, correct?
Yes.
Well, they have trooper.
And there are
Paul.
troopers within the Massachusetts State Police Collision Analysis and Reconstruction section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction Section who engage in accident reconstruction?
Just based on what I've seen in this case.
Right, based upon what you've seen in the case, that's a fair statement.
And I just know that those people are doing it.
Are you familiar with a Massachusetts state trooper named Joseph Paul, P-A-U-L?
Yes.
And you
Well,
know,
I'm familiar with his reports. I don't know the man.
okay, familiar with Trooper Paul through his reports in this case, correct?
Correct.
And are you aware that he was assigned by lead investigator, former Trooper Michael Proctor, to be a constructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul? Do you know that?
Well, you put a lot of things in there. I know he issued a reconstruction report. I don't know who told him to do it. So the first party question, I don't know, but I did see a reconstruction report from him.
You were retained. And so do you recall, is it the date, January 29th of 2022? Is that a rough time period of him being assigned, or you don't know when he was assigned?
I don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do you know when the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2024. Is that correct, sir?
No, I believe we were retained a couple days before that.
A couple days. Okay.
Right.
So
Actually, I might be able to find out if you'd like me to look at the documents.
it's not all that important. You would say it's within a week of September 23rd, 2000. It was in September of 2024.
I believe it was in September, yes.
Right.
I would
So-
want to double check.
That's 2.5 years from the date of the incident in question, if I did the math right, correct?
No, I never thought about it.
I can do the math for you.
And as
Yes.
we just discussed, and you stated on your direct examination, you have no dog in this fight, correct?
Correct?
On November 5th of 2024, your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea. I don't get the billing or the statements.
This is just to prevent when Hanky is going to ask Aka.
Yeah.
Do you recall whether Aperture has, well, do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that.
So
we're
you
an
would,
engineering company. We bill for our time.
so
Well, not your
you
buddy-
know that Aperture is getting paid for its work in this case, correct?
We are billing for our analysis work.
Well, you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir, you are a senior vice president of Aperture, are you not?
I am?
You would know, wouldn't you, if your firm was not getting paid for work since September 23rd of 2024, wouldn't you?
No, probably not. Usually it takes, 9, 10, 12 months of not getting paid before the accounting department reaches out to me.
Exactly.
It's been
So you've been
9
on this for
months.
2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid,
No, that's wrong. He's not been on it for 2.5 years. He's been on it since September last year.
September
Yeah.
last year, which is 9 months.
9 months. Yeah, you messed up, Alessi, but you're 9 months in.
you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry,
9
sir.
months.
Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024.
Yeah.
So that's
You
9
fucked up,
months.
Alessi.
less than a
This
year
is
ago.
bad luck.
Understood. I'm moving on to the next question because I want to move away from that discussion and just
Okay.
go right to the bill. You, as you sit here today, do not have a recollection of whether
It has
Aperture
been 9 months,
paid. Is
though.
that your testimony?
Yeah.
It has nothing to do with
Still fit,
recollection.
unless he
I'm
just
not part of
goofed.
that process. We have an accounting department. I don't have any involvement in that.
Are you, so is your testimony you have no knowledge
Got
about
bought
any
up.
contractual relationship between Aperture and the Commonwealth?
Oh, no. I was sent a contract by the Commonwealth to sign, so I'm aware of the contractual agreement, but the day-to-day or month-to-month invoicing and billing, I'm not involved in that.
Okay, so you're aware there's a contract between Aperture and the Commonwealth,
I signed it.
and you signed it. And wasn't that contract obligating the Commonwealth to pay for the services of Aperture? Isn't that the purpose of the contract, in part?
In part,
Yes.
sure.
Yeah, it's a legal obligation of the Commonwealth. Your firm does work, and the Commonwealth pays for it, correct?
That's the idea.
Right, and so you know about that contract because you signed it.
Correct.
Also, you testified on direct that there was a purchase of a Lexus exemplar for your testing.
Correct.
Who pays for that Lexus exemplar?
Aperture?
And is that then cost passed on to the Commonwealth?
No.
So you pay for the Lexus, you don't pass that cost on, correct?
So what we're doing is we paid for the Lexus. We're keeping it till the trial's over. We're selling it and charging the Commonwealth the difference in the price.
Exactly. That was where I was going, sir. So,
But they're only paying the difference. So, and in theory, if we sell it for more in California, then we'll reduce the bill.
okay, I don't want to speculate. I just wanted to see what the obligation was. So
The
it's-
obligation is the difference.
Exactly. So the obligation is the difference. Are you aware that on
Magically enough, that Lexus was sold to Mrs. Welcher for $1.
Shocking.
April 5th, 2025,
No, it's not. Lex.
the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So the
So Brennan is no longer the most expensive hire in this case.
Not anymore.
Commonwealth is
But in all
obligated
fairness,
to pay at least
didn't they sponsor the Norfolk County Bar
$325,000.
dinner the other
And
day?
is that correct?
You know, they got some of
That
that.
is
No, it wasn't
my
the Norfolk
dressing
County, it was the
illegal opinion
Massachusetts
now about a
bar.
contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that, are you aware that Aperture has been already paid $44,510 for its work? Are you aware of that?
The second time you asked me, no, I'm not aware of anything we've been paid.
And as you stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
That's not what I said.
Well, no, my question is, you've been on the case, you said, since September of 2024, when we were talking about dates, you said that was about 6 months that your firm's been retained. Did I have your answer correct about how long you've been on it?
I guess it's closer to 8 months.
All right, so 8 months. So for 8 months of work, about $400,000. Is that correct?
So there's 3 offices working on the case.
That's not the
There's
question.
the Boston office.
Not the
There's Mr.
question.
Burgess's office.
Not
and
the
there's my
question.
office in Long Beach. I only know about the billing from my office.
But you signed the contract on behalf of all of Aperture, not just your office, correct?
That I don't know.
Nope.
But I definitely did sign a contract.
Would it refresh your recollection as to who you signed the contract on behalf of, whether it's all of Aperture in all offices, if I showed you the contract?
Sure.
May I put you?
Yes.
May I put you?
Yes, sir.
Sir, may I ask you-
Yeah, could you direct me so we're not wasting time?
Well, what I'd like to do, with the witness, Your Honor, is just ask the witness a question with regard to it.
Why don't you just take a look at that, Dr. Burgess?
Thank you.
So no matter the outcome, this company is guaranteed $325,000. And they don't even have to do anything. It's just, yeah. It's just a block payment.
I have a few more questions before I do that, Your Honor, for foundation purposes, but with more than a question.
Right.
Would you like me to start with?
So-
the refresher?
Go ahead and start with refresh. Go back to the podium, please.
Sure.
Thank you.
Thank you, Your Honor. Dr. Welcher, does that refresh your recollection as to the contract you signed on behalf of Aperture with the Commonwealth?
So it lists the legal address as my office. So for my office, yes.
So are you saying that therefore,
What?
and did you see the amount that was in the contract? Did that refresh your recollection?
Oh, no, I didn't even look at that.
Do you recall the amount that of obligation that the contract relates to in this document? Do you recall that?
You just asked me that earlier, and I'm taking what you said to be true. So It was like $325,000. I have no reason to disbelieve that.
And is there also a total, do you recall the total maximum obligation for the contract that's listed in the contract? You
No.
recall it? May I approach, Your Honor?
Okay.
And Dr. Welcher, I'm now going to, you asked me last time, I hope this is helpful.
Please.
You said, please point to the applicable part so we can do it faster. I am now pointing to that part and see if you can just look at that and see whether this refreshes your recollection on the maximum obligation of the contract pursuant to this
Bio
contract. Without saying what it is, just does it refresh your recollection?
No, but I don't have any reason to believe it's not correct. And that is my signature on it.
Right. And we got started on this conversation, tying it to, well, we got started on this conversation with regard to a statement you made earlier in your direct that you didn't have any dog in the hunt. You recall that statement in the beginning of your direct testimony.
You misquoted me. I don't have any dog in the fight.
You don't have any dog in the fight.
Correct.
Thank you. Now, switching topics.
Okay.
You submitted an updated PowerPoint presentation, the one that you went over on your direct examination. You created that presentation quite recently, correct, sir?
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this.
Mhm.
The updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks, 2 weeks?
I don't actually know without looking at the documents.
Well, was it more than 3 weeks ago that you created it?
I still don't know without looking at the documents.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated presentation
2025.
before or after April 22nd of 2024?
I don't know.
Alessi, get your numbers right,
you
man.
know when,
Hold on one second. Dr. Welcher, I'd ask that you not do.
Not look at,
anything.
okay, I was going to try and answer his question. My apologies. I will shut it down.
Thank you.
You're welcome.
if I may, Your Honor, please
Yes.
continue. Are you able to determine when you created the updated presentation?
I think so. That's what I was attempting to
Your
do.
Honor, may he do that?
Yes, I'm going to see counsel at sidebar while you pull that up,
Thank you,
please.
No, he definitely meant, I think he meant this trial. I think he just said the wrong date. April 2025, because Aperture wasn't involved in the first trial even. In the meantime, though, if Alessi could clear his head a little bit and get these numbers accurate, it would go a long way in speeding this up and boosting credibility, I guess, for lack of a better term. Alessi, you're better than this. We know you're better than this. Everybody knows you're better than this. Get your dates right. Because that's essentially all that's happened, right? He's missed 2 dates, and now the whole thing sounds wonky so far. I can't pull it up, let's go. But give him the papers to refresh his recollection. We stared at it for hours yesterday, and he doesn't know when he created it. Even Sweaty Tuft did. Yeah, he seems to be a little bit evasive, right? Like he knows these things. He knows that he signed over a $250,000 contract with the Commonwealth. He knows that. He said in voir dire it was changed 8 to 10 days ago. I think that's about right.
Welcher, what I'm going to ask you to do is get whatever information you need for Mr. Alessi's last question. Mr. Alessi, I need you over there. So,
Yep.
and once you get that answer, I'm going to ask you to shut your computer down, or at least put down the cover. Thank you. All right, so you can answer Mr. Alessi's question.
Thank you, Your Honor.
Could you give me the question again, please?
Yes. when did you create the updated presentation that you reviewed in your direct testimony?
So that addition I made was taken out. It wasn't in my direct
Sir,
testimony.
If you can just hear my question, it's this. The version of the presentation that you put on the screen, when did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday.
Okay, good. Now, the version before that you created yesterday, when did you create that version?
The day before.
And then the version before that one, when did you create that?
I mean, I save it every day.
Understood.
So every day.
So you've changed the presentation every day since when?
No, I don't think I've changed the presentation every day.
That's my question.
That's what you
My
just
question
said,
is,
bro.
How many times have you changed it within the last?
How can you use save and change interchangeable? This is Valhalla. I pledge I'm gonna give you enough singles to give to every girl at the mouse here.
Outstanding.
And when you sit there and say, but I don't have, hey, I pledged it.
Last 2 weeks, your presentation.
Try and cut to the chase here.
Sure.
That slide was added on May 13th, and then it was taken out before I presented it here. So it was not in my presentation here.
Right. So thank you for that answer. So
You're
here's
welcome.
the question. Your first version, as I understand it, of the slide presentation was January 30th, 2025. Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
Assuming the trial started April 22nd of 2025,
There you go.
changed your PowerPoint presentation during this trial, correct?
Correct.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time I changed it was like 10 minutes ago. So in response to various discussions, I've been making continuous changes to it.
I want to make sure you finish your answer. Sorry,
No, I'm not sure how much granularity you want to that answer.
Right. So
What a
you
tool.
created January 30th, 2025. You made your
13th.
pardon me.
Oh, the original one. Sorry,
Yeah.
January 30th, modified May 13th.
Right. If I could finish my question.
Farrell will be doing her interpretation of the mouse here at the meetup on Friday next week.
And I might be able to shortcut this. Thank you. So you created the original one on January 30th, 2025. You made your first amendment May 13th of 2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy when we're in the courtroom, but it was yesterday. How many times had you changed your presentation from January 30th to
Hey, Kimmy! How you doing, honey bunny? You are, as always, wrong. They can use third-party culprit. I know understanding words can be hard. I have the same problem. Kind of like this guy. The headlight said no, but his tailpipe said yes, yes, yes. So they can use all the third-party culprit they want because that's their right. The only thing they couldn't do was mentioning in the opening statements, and they can't mention colon. You know this, Kimmy, because even though you play dumb on the internets, I don't think you are that stupid. Because I love you, girl. This guy, he's really bad for you, right? Are you a little bit disappointed that this is what the Commonwealth that you believe so much in has put out there? If I had spent as much time as you did yelling about how great Brennan was, I would feel a little disappointed. But hey, as the good book says, there's more room for a sinner in heaven than a holy man. So I hope before the day is over, Kimmy, you don't have to say sorry. You don't have to say I was wrong. But I'm so glad to see you. You know I miss you when you're not here, girl. Tell that hubby that you're going on a trip next week and meet me in Tennessee. I'll take you to the mouse here.
2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was the May 13th change. Half of that was in response to objections from the defense. I had to add all the paths to where everything was. Then when I got out here, Mr. Brandon asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days. And then
No, Kimmy, honey bunny. I know when you see me, you get a little flustered and things starts moving in your head. It's okay. I got butterflies in my stomach as well. And it's a big stomach. There's a lot of butterflies. But you make that happen to me. They can mention everyone they want except colon. That's what it was. And this guy is just some expert who said he clipped John O'Keefe. He can't tell you when and how it happens. He's even worse than Trooper Paul last year because he at least tried to say when it happened. But honey, let's wait and see till cross is over. You know, direct and cross. And then the defense get to put on their case. I hope you keep an open mind because I know I have an open heart for you.
I've modified it a couple times today based on rulings from the judge.
Okay, let's break that down. You said half of the changes you made on May 13th related to what? Because I want to know about the other half.
Sure, there was two changes. I added the extra path of 138, and then I was told that the defense was having problems with my PowerPoint, so I had to go in and add the paths to every single slide about where the evidence came from, because they were saying I didn't provide everything, and I had provided everything.
All right, so
that was the second half.
Yeah, I want to go to the first half, sir.
Sure.
And I'm going to try to shortcut this.
Please.
And if I'm not clear, you just let me know. I want to talk about the first half. You called it, I didn't hear it. It was like, did you say path?
Path.
P-A-T-H?
Correct. The path Miss Reed was driving.
Right. What you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
All right, so that's what I wanted to get to. You changed the first half based upon statements you allege that Ms. Reed made. Is that correct?
I changed one slide. There was 130 slides originally, or something like that. So,
yeah, but I've heard the lawyers in Rhode Island is a little bit dim. But I also I agree with them that, and I think they have been doing it great this time. Don't rely too much on the third-party culprit because, as you have seen, the Commonwealth haven't put on a case. I actually think, and I hate to say this, Kimmy, because I know he has a special place in your heart as well, and I get a little bit jealous on him. Lally was better than Brennan because at least he tried to prove his case. Brennan, not so much. But honey, I still love you.
half of the changes on that day, which was one slide, I added one line to the bottom of the previous slide.
Did you consider that change significant?
No.
Well, then why did you make it in the middle of trial if it wasn't significant? Why didn't you just leave it off and then discuss it in terms of testimony?
So A, it ultimately was left off. B, because it was insignificant and I didn't need to have it. So the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the path that I gave, the way she could drive, I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
So you were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Ms. Reed. Is that correct?
I believe that, yes, that is correct.
Do you know that clip has been in existence for months?
I don't believe I got it until April.
So a clip that has been, assume the clip's been in existence for months. You just got the clip.
Dr. Welch, I have to ask you
Oh, I'm
not to
sorry.
refer to
I'm
that.
trying to be helpful.
Close your
Yeah,
computer.
let me close it. Sorry. I was trying to answer his question.
But you shouldn't. You should do what
So let me
you're a
ask you
witness,
to close
goddammit.
it.
You
Yeah,
have
that's probably it.
you have testified in hundreds of cases.
So assume the clip that
I'm jealous of all the attention Baker gives to Kimmy. You lucky dog, you Kimmy. Well, Lynn, you know how it is. Sometimes eyes meet and sparks fly, and sometimes some people say something dumb. And I've always loved I'm not going to say a slow woman, but a woman who will believe me when I say this is 6 inches.
You said was the basis for changing your PowerPoint on May 13th after the trial started had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
What was tell me the circumstances by which you got the clip. Did you ask for it?
I was told there was a new interview.
Okay. Who initiated the conversation about the new interview?
I don't know if it was Mr. Brandon.
It was someone associated with prosecution?
Yes, I wouldn't have known about it.
Exactly. So somebody affirmatively communicated with you when about this clip?
I need to look, but I remember it being about mid-April.
Mid-April.
So you had your theory, and someone called you and said, "Hey, have you heard her talking in an interview?" And you said, "No, I better go in and change my entire scientific engineering-based testimony because someone who allegedly was so drunk she can't remember the night said something in an interview, and that is more important than 1 + 1 making."
If I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that clip?
When I got the clip, I wasn't asked to do anything.
What did you do with the clip once you got it?
So they then indicated there was this suggestion of an alternative route. So then I looked at the alternative route description and added the alternative route.
So it was suggested to you by the prosecution that you look at the clip and they pointed out that there was an alternative route they wanted you to look at?
So I took it to be, we have additional evidence. Please look at the additional evidence and add it to your analysis.
On the topic of additional analysis by Aperture, while this trial is going on, are you aware of Mr. Burgess submitting a report dated May 8th of 2025 in this case?
Yes, I received that report on May 8th.
Right. And so you were aware of the creation of that report on May 8th because you got a copy of it, right?
Correct.
Were you aware that Mr. Burgess was
No, she did it constantly yesterday as well. This guy is just an idiot.
intending to submit that May 8th report to the Commonwealth?
Yes, we had a discussion before that he had found new information that changed the timing.
Oh, he had found new information. What is your basis for saying he found new information as opposed to the information always existed? It's just it was pointed out to him that that should be looked at. What's the basis of your understanding that he found new information? Yes.
I'm going to allow the question, but you have to ask it differently.
I will, Your Honor. Thank you. What is the basis for the statement you made that Mr. Burgess found new information?
I guess it was his meeting in our discussions. He indicated that he had found new information.
Did you ask him, what do you mean by new?
No, I took it at what it said.
So do you, as you sit here today, have any basis to say that that information is new as opposed to it's always been in existence?
Yes,
What is that?
what he told me.
Oh, so you relied upon the representation of Mr. Burgess. You didn't have any independent document to determine whether, in fact, it was new.
I don't quite frankly care whether it's new or not. I just care what's in the data. Whether it's new, old, I don't care. It's not relevant to what I'm doing. I don't say this is new data, this is old data. I just care what the data is.
Sir, has Aperture ever submitted a report, a changed report in the middle of a trial for your knowledge?
I have no idea.
Do you know whether Aperture has ever submitted an amended report in the middle of a trial? You said you testified in federal and state courts. Can you recall one instance where Aperture has submitted an amended report in the middle of a trial?
So Aperture is like 290 people. I can only speak for myself. I have certainly done amended analysis. Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts. I very frequently have come up with new analysis during the trial.
Sir, my question is, as you sit here now, can you state one court case where you or Aperture has submitted an amended report in the middle of a trial
I cannot speak for Aperture. I can only speak for myself.
Can you answer? Oh, speak for yourself. So can you then, for yourself, recall any instance where you submitted an amended report in the middle of a trial?
Amended reports? No. Amended analysis? Yes.
Thank you.
He's such
You're
a
welcome.
tool.
Mr. Leslie, is this a
Yeah.
good time for a break or
It-
5 more minutes?
It's a good time, Your Honor.
Okay. All right, folks, why don't we take our
So, in
The
the
answer to all of those questions in the last 5 minutes was no. It was one question. The answer was no, and he found a way to backdoor disregard the entire thing and draw it out for 5 minutes.
he's been on the stand for roughly an hour, and he hasn't answered one question, yes or no. He has answered every question was, well, it depends on what is.
Depends on what the definition of is.
Yeah. Can you use it in a sentence? Did you change your report? I saved
I
it
get
yesterday.
Can I get the root origin of the word, please?
This isn't a national spelling bee. Having an engineer who just said to a scientific engineering certainty,
Not
I can
scientific.
prove it.
Not
No,
scientific.
well,
The
he,
engineer.
he was asked by Alessi about scientific certainties, but then he said, I changed my engineering facts, which is hard facts. It's replicable facts, because Karen Reed in an interview said she might have taken another route home. But you have the trigger events. You have the mileometer. So you know what route she must have taken that day. You can see when the car was shut off, you can see the distance. Why didn't you already say, okay, this is Fairview 34. Her car drives 6.2 miles and turns off. Now I can do, because do you do a 4-mile road where she goes slow, and then you do a 6-mile road where she goes really fast? Again, nah, I look at the science, but that's not important. Hey, by the way, this case, and I don't know if any of the mods have shared the picture that I took off the screen when I found out how gory it really was. So it's in the Discord. As always, I'm not the head of a kindergarten, so yes, you will see, we cover a lot of dead people. You will see pictures in there you might not like. So just be mindful. We would love to have you there, but we don't do kindergarten. So we will sometimes show bad pictures. I know some people have talked about it earlier, but go look at that picture again and tell me how you felt, Hank Breen. I know you did it for the shock value, but all those injuries that happened at a similar or slightly higher speed, and you're claiming, nope, scratches to the arm is exactly the same as a ruined,
Ruptured liver.
yeah.
Yeah.
Certainties, much like birds, simply are not real. No, and you were certain that you liked sweets this morning, which is wrong. You don't like them because they don't burn witches.
They do have that Swedish bikini team, though.
Yeah, but probably that's why. It was a cute little girl, well, not girl, but a cute little young woman who was talking about Sweden. And this American was, why is it so light out? Because we live in the north. Oh. Because in the summer, it stays, well, it actually never gets dark in the summer. But then we have 5 months of it never gets really bright out either. I don't even think he took notes. I just think he's looking at his report and looking at his computer, and Bev having to constantly remind him, you are not allowed to look at it. This guy, as Brandon noticed, has had thousands of cases according to his CV on Aperture, so maybe 2-3 cases. He should know the rules of court.
He should. You would think. Being the senior vice president of Aperture, you would think that he's familiar with the ways of courts. That's not like an unusual thing either. You can't just like stare at your material and read it during testimony. That's not how it works.
No, you can ask to refer to it to refresh your memory, but you can't sit. And on Monday, I went into the courtroom. In the courtroom, I took out my computer. Yes, I remember everything. Did you see my girl Kimmy was here?
I did. I saw that.
I might need
I was happy for you.
a minute and a half in the refectory room.
What are you going to do with the other 60 seconds?
Well, go to the shop, buy a pack of cigarettes, and just lay there and say, I wish she could feel it.
Oh, Kimmy. Oh, Kimmy.
Yeah, he needs the laptop because the data keeps updating. So you work from a hypothesis. Well, there's many hypotheses that kind of comes up. You start with one. No, I start with more. But you start at some. More come up and more go away. Answer the effing question.
Can we also take a second to acknowledge that Brennan has pretty much lied through his teeth about every single question regarding communications with Aperture?
Yes.
Information being sent or received from Aperture is pretty much just lied through his teeth on every single one.
And I love that they have a guaranteed $325,000 lump sum. Because I saw the money that they had spent. The 3D is like $1,000. This guy is getting paid $700 an hour. I don't know if they are billing that on top of it. $700 is roughly normal expert pay. Bergie's got $400, I think. But still, you can buy a whole ton of experts for $325. I don't think Arca made $325,000 from the defense. They made $500,000 from the Commonwealth. Well, from the feds.
How long is the break? I don't know.
It's
not very.
It's a bev break. It's only been 11 minutes, so sometime between the next 5 minutes and tomorrow.
It's not like a lunch break, so it shouldn't be all that long. But who knows with Bev? Yeah,
that's a rule 14, Val. You can get in massive trouble for violating that. Doubt Brennan wouldn't turn over all communication data and notes of conversations. Yeah, of course he will, especially because the defense have asked for that earlier. So he would never, ever, ever. And Brandon, I didn't see this one. Give him the papers to refresh his recollection. We stared at it for hours yesterday, and he doesn't know when he created it. Even Sweaty Tuft did. Hey, the Tuft was hanging on for dear life. Thank you, Brandon. I missed the Tuft guy. At least he was an idiot that knew he was an idiot and just yammered on.
Yeah. And he's an actual expert. 250 grand. That ain't bad. That ain't bad for an expert.
I offered people could sideswipe me at 2 miles per hour for $1,000.
I'd do that. I'll put my arm in whatever position you want me to, too.
Yeah.
How's that? Yeah.
Oh, Val read it. Well, you got double your money worth this time.
I couldn't pull it up, so I guess that's fair.
Probably more than that anyway. Notice Brennan accuses the defense of things he's guilty of. Suspicion hunts a guilty mind. Yeah, and he filed a Rule 14 violation notice today because they impeached his own expert with information that is publicly available. It's not like they sent a PI out and found out that he was banging his manservant. They just took his CV that's filed in the court system, and he then claims this is trial by ambush. No, that's bad preparation for you, because you, of course, should have done your due diligence with your experts and said, anything I need to know about? Well, Jessica Hyde, yeah, I got dismissed once as an expert. This guy, we haven't heard about it, got dismissed a couple of times because of his methodology. I love that he still don't want to say what his methodology is.
because
he
he doesn't
hasn't
have
answered.
any.
Well,
It's not based in scientific reasoning. It's like, I watched Mythbusters twice. I think I can figure this out.
Will you cosplay John O'Keefe and the Blue Man Group for that one? No, that's extra. Any paint applied to my body, various degrees. I would say the arm would be, I don't know. I'll check with Amaranth how much she gets for putting paint on her body, and then we'll figure it out.
Can we get a catalog, body
Yeah.
pricing, body paint?
Kind of like going to the
this.
butchers and saying, I want that
Yeah,
piece of the
little piece
cow.
of the flank right there. Little piece of the flank.
The safe word for this trial is theory. Also acceptable is hypothesis. What pictures? The pictures. The last slide they showed with the dead body,
From California.
and the
pedestrian
injuries. I didn't know if normally you and Jemima is way ahead of me, but I don't want to hurt anyone's fifis. Maybe we'll just put a disclaimer. This is not a safe space. I think actually that is in. Let's be nice.
Hey, if
all
Judson
I'll say.
can show it, Marissa, so can you. And that's advice I would live by if I were you. If
Yeah,
Judson
but it's
can
in the
show it,
Discord.
so can I.
Some people get mad when there's bad pictures in the Discord. By the way,
Don't you have
join the
a
Discord.
NSFW section in Discord?
No, I just have this is the case because it's part of the case. I don't tell you you're not grown up enough to make your own choice if you want to go in and watch autopsy photos. That's why I don't show them on screen. I tell people they can see it on Discord. Then people shouldn't get surprised when there's autopsy pictures. Amaranth home invasion was scary. Whatever came from that?
I haven't heard anything.
No, it was totally real, according to, was a DUI guy who had talked to her, and someone got pew-pewed, but then it went away real fast, and then the next thing was her and her husband fighting, which sounded kind of like, I'm not saying that this poor lady doesn't have the worst luck in the world, but when it sounds more scripted than a TNA promo.
Safe word for this trial is don't answer the question. Yeah, that checks out. It's been the constant so far in the state's case.
I, for one, am actually surprised they know the difference between a theory and a hypothesis. It's a rare sight. Yeah. So now can we show other dog bite? Hey, I'm Danish. I don't. One of the things that is very different in Danish and American culture is I choose to just close my eyes if I don't like what I'm seeing. I don't need someone to tell me, oh, this is bad. I can look at it and say, oh, fuck that. I don't want to watch that. It's we don't have NFSW in Denmark.
I don't think that's what the comment was about, Baker. I think the comment was about in the case.
Yeah, I know they want to show pictures, but there were some people getting mad about pictures of dog bites. And I'm just saying, if it was me, I don't care. I know I have a big American audience, and it's a different culture. I have to kind of understand that. That's why I have Jemima and Marissa and Jamie and Mo to kind of say, no, you're a retard. And sometimes they give me good advice as well as, you're a retard, don't do it. But that's most of our conversations. There is no NSFW on my Discord. In Denmark, we just say, hey, you're grown up. You make your choice. Do you want to see it or do you don't want to see it?
I'm all for it. For it.
Because if you need a safe space,
the rating, like,
don't go in where it says, oh, this is a murder trial, and it says documents or evidence. I might don't need to go in there. That's
NSFW, Kim, stands for not safe for work. Not safe for work. Usually it involves gore or nudity or a combination of the two.
Yeah, don't share your nude pictures in there. That's why I have my DMs. Brandon, stop sending me more nude pictures. he has gotten into an artistic period. I'm just saying the stuff he
getting
does.
flexible.
He's getting flexible, but after he saw those that painting yesterday, I didn't think I could be this disgusted by a blue mushroom. Maybe it's because of the big ring in the top of it. It's weird.
Well, that got weird.
But yeah. Yeah, he did ask me to send proof of the size of my peen.
Oh, let's go.
It's because I said if that was the flagpole yesterday, my peen is the size of a Coke can. And he just wanted to check it. Got any naked pictures of your wife? Want to see some?
That's terrible.
I luckily was married before digital photos was a thing. Well, it was a thing, but we didn't. So no nudies out there. Yeah, they really zoomed in on that, and you can see that big hole in his arm.
Yeah, it was pretty unnecessary, I thought. But
yeah. Hope you make it to Tennessee. I really appreciate your stream and all the nice people in chat. Pimpanella, Dankevel. And I too hope that I don't have to stay in Finland. But if I do, I'll probably get out. I will get to Tennessee. It's just a matter of how long will I stay in Tennessee. Because
I'd be okay if you overstayed your visa and then couldn't go back or whatever. That's cool. You'd be all right.
The problem is getting there to begin with. It's if that strike in Finland stops me, then you might have to sit on the tarmac at 3 a.m. I think that airport closes at like 11 or something. So,
well, I don't think they're going to turn your plane around. Like if the plane doesn't get there till like midnight, they're not going to be like, "Oh, too bad."
No, but it's the airport is closed. But the problem is if I fly to Helsinki and I can't get from Helsinki, then what the F do I do? But they said, I called the hotline, nice Indian lady. Really, they should, I don't understand. I have noise canceling on my system that I turn on, so I can't hear it. If someone talked in the other room, you wouldn't be able to hear it unless they talk really, really loud. Because we have noise canceling on our system to not let everything go into the microphone. Why can't these call centers in India have British Airways, buy them a better headset? She was really nice and she said, don't change anything now. If it becomes a strike, then it's our problem and we will have to pay for it. If you change something, you'll pay for it. I'll wait. So if they have to rebook me, it's their problem.
Well, that's nice of her, I guess.
Yeah, that's fine. A fun bonus picture. Oh.
Ooh.
Oh. That's a movie quote. I wasn't asking for nudes. Well, too late, Bob.
Yeah. Should have specified earlier.
You did not ask for them. I love when they're talking to each other about your conversation. That's the straw that breaks the camel's back. No, the thing that was really annoying was if they just talked English so you can kind of listen and understand, but they were yapping in Indian or Pakistani or whatever it was. And it's really annoying because you can't understand it and your brain just fixates on it and says, what's going on? What? And you can never really hear the person you're talking to in the call center. It's kind of like, hey, yes, if you change it. And then you have this, and at the side who's probably telling her about her mom's gravy recipe or something. Just give them. IKEA have like I have an IKEA table, and there is a kind of like a cubicle thing with soundproofing that you can buy in IKEA, and it doesn't cost. It costs like $100 for soundproofing of my table, so I could could put it up if I sat next to someone, so it wouldn't be that noticeable. Things we go through on breaks. I love that it says thoughts on a short break, and we have now been on break for almost half an hour. Oh, I just had curry yellow as my game color. How did they pick the route Karen went home? Do we know how she went home? If not, how do we have all this other GPS data? Well, the GPS data we have is John's Waze app. It's not the car, because I don't know if this is true. Again, I hear both sides, because the aunties claim she deleted her GPS data. Some people say she never she disconnected the GPS data for the car, and other people say it disappeared while in the custody of the Commonwealth. So they just did the Google map and said these are the 3 routes she could have gone home, and this is the amount of time it would have taken. So there isn't any GPS data showing her route home, and because magically all the cameras were out at that point, we don't know. Hindi. Oh, sorry, not Pakistani. Hindi.
All right, whenever you're ready, Mr. Lessie.
Isn't Pakistani Urdu? Or is that Afghani?
That I wish I didn't have to address. Dr. Welcher was just using, at least my observation, his computer. He still has monitors on his desk. Could we have all that removed, Your Honor?
It was
Closed. Yes.
Would he
It
open?
wasn't closed. It was mostly closed.
Did you just
Yeah.
turn it off?
No, but I will. I closed it. You like want the computer all the way off, or just everything?
Is he going to need to turn his computer back on?
I do not see a need for the computer to be turned on. Do we have?
Brandon, actually, we had a murder case in Denmark. I have talked about that back in the beginning when I started my channel, about that girl who was put into 247 pieces, I believe it was. He got swiped because, well, they kind of found some things, but the reason why they could pinpoint him was he had put in an aftermarket GPS that he could disconnect. But unfortunately, even though he disconnected the GPS on that switch that he bought specifically to be able to unswitch the GPS, the system still kept recording. So they have him the entire night driving around with this girl, and where he raped her and where he then dumped the body. The GPS will, hey, there's a reason why I right now am getting a lot of ads for stuff near Tennessee. It's always listening and surveilling you. Anyone who believes I'm off the grid, man. No, you're not.
Did I tell you when I went back and watched the first trial, like whatever it was, 20 something days of it, all of a sudden every ad I got was all about Ozempic, menopause medicine. It was all related to like old fat women. I was like, what the hell is happening? It was for a solid month. That was all the ads I was getting on any device I picked up. It was very, very saddening, if I'm being honest.
Valhalla, you have been a YouTuber for 3 years now. You make enough money to pay for premium, you cheapskate.
Stop it.
Can you put a goal so you can just at the beginning of the month enough money that you can pay for premium?
The ability to put the presentation and documents from our
So I'm
sub.
going to see counsel at sidebar,
Sure.
please.
Oh, Jesus Christ.
So
Have the ability to put the presentation and documents from our
So I'm
sub.
going to
Was he just reading off his computer again?
I'm sorry.
during the lunch break, I know it takes you a while to set up in the
Yeah.
morning. I'm going to ask you to take all that down during the lunch break, okay? Thank you.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, we left talking about the amendments you made to your PowerPoint presentation. And in terms of the amendments, are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
No.
And you began testifying the day after yesterday, correct, sir? Day after Memorial Day.
I testified yesterday.
Yes. Are you aware of any activity in this trial of any kind before you testified yesterday?
Again, as I mentioned, I've been getting random emails, and then I've been seeing it pop up on my news feeds as well. But once I was aware of the reclusion, I made sure to not review any of that. But as recently as last night, I got an email that said biomechanical engineering job, or like applying for a job. And I opened it up and it was some internet troll.
Sure. I'm asking about emails from the prosecution.
Oh, no, there's been no emails about what's been going. I mean, there's been scheduling, when am I going to come, things like that.
How then was it determined that you were going to be able to amend your power presentation if you weren't communicating with the prosecution?
I mean, they asked me about the witness statement of 138 right around May 13th.
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a phone call.
Zoom meeting.
Didn't he just testify he hadn't talked to them? And now he has?
Well, he said earlier that he had. He said that Brennan was the reason that he came up with the amended.
Yeah, but he
stuff.
also said that he changed his
That's what I
report
meant
just. Again,
Hey, yesterday, 8 days
yeah,
ago.
and he said it
Changes
was
it all the
on.
time.
It was because of the interview that Brennan made him aware of, but it's after that pursuing Dr. Burgess testified that it happened. Yeah, this is opposite day. I'm going a little bit back so we can hear, because he hates the microphone.
They asked me about the witness statement of 138 right around May 13th.
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a phone call.
So there was a communication with the prosecution. Might have been by Zoom, might have been by another method, but there were communications while this trial is going on relative to you amending your PowerPoint that ended up with an amended PowerPoint on May 13th. Do I have that correct?
I believe so.
So trial by ambush, Brennan.
Going to switch topics.
Okay.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain tech stream events, correct?
Correct.
EDR data.
I'm sorry, my role.
Your role, yes. EDR, and just for clarification, EDR is Event Data Recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, Event Data Recorder.
Sounds good.
EDR data does not show the location associated with a tech stream event, correct?
I just got a cash app
In this particular
from Hellfish Haven. It says 1 month of YouTube Premium individual. Thank you, buddy. Appreciate you.
vehicle, it does not.
Then buy
And
it.
the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a tech stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question slightly different way. The ER.
We have been on break, and then we came back, and then he testified that he has been in contact with the prosecution's office and changed his report after talking to them. And now he is saying the EDR isn't what unless he claims.
The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a tech stream event, correct?
That is correct.
Instead, every tech stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple tech stream events in a single key cycle, right?
Correct.
And every time you start the car, this when you push the button, that's a new key cycle, right?
That will cause a key cycle.
And the EDR data indicates the number of seconds into the key cycle that the particular event occurred, correct?
The EDR data, no.
So EDR data gives you no information about the number of seconds into the key cycle that a particular event occurred.
You're confusing EDR data and tech stream.
I'm not, sir, I'm just
Oh, you're
asking
not?
a question.
So
If it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, sometimes it has information about GPS date and time. Sometimes it has ignition cycles, which are a little bit different than key cycles, which is why you frequently have different ignition cycles versus key cycles in EDRs compared to tech stream.
So let me ask it a different way.
Okay.
The tech stream data
Mhm.
indicates the number of seconds into the key cycle that a particular event occurs.
Yes.
Is that correct?
That is correct.
In order to properly determine the location and the timing of a tech stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes, that tech stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a tech stream event.
So the tech stream tells you the trigger event and it tells you the key cycle. So I'm not determining that. I'm reading that from the tech stream data.
Okay, so in order to properly read, to use your verb, the location and timing of a tech stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the T.
This is pivotal if they can prove that they used the wrong key cycle. Remember last year when we did the count backwards, it didn't match. There was at least 5 key ignition turnings, keystrokes, whatever the name is, that was missing. This will be pivotal for the case.
The tech stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence in the tech stream with the mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct tech stream event?
No, not necessarily. Again, you have to take the totality of the data.
There you go, yo.
My question is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the tech stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So again, the tech stream event tells you the trip and it tells you the time. If you're saying I'm, say, associating that with the wrong infotainment information or vice versa, then that would be wrong. But the tech stream data tells you how much time is associated with each trip. There's no difference.
That's not the time he's talking about, you absolute pillock. He's asking you, does it say it was 5 o'clock? Does it say it was 5:20? He's not talking about the time. Well, he's asking about the time, not the stop clock time.
There.
If you associate the wrong trip with the wrong key cycle, then your estimate of where the tech stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
Let me try it a different way. Your analysis or anyone's analysis and conclusions regarding the timing and the location of the tech stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No. Again, you need to take the totality of the data. So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the event. So this is considered a tool in the analysis process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of tech stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the tech stream. If you are attributing an event to the wrong trip,
Don't laugh, your stupid little laugh. When you don't understand, you clearly understand what he's talking about. He's talking about you took the wrong key cycle, period, and then added a real life time to that. And if you did that with the wrong, then the real life time would also be wrong. Fuck, he's stupid. Well, he's not
which
stupid.
has a
He's
fixed key cycle,
He's
that could be a
confusing
problem.
everyone.
Exactly. So if we could go, if Your Honor, if we could publish a slide, please, that is in
Man,
evidence.
Nightbot's
Thank you.
being stingy with the Swayzer today.
Pardon me?
Yeah.
Slide number.
I've got slide 9. Mr. Wolf, yes, I've got the correct one. Thank you, Your Honor.
Let's see what it is.
So I'm going to use the acronym VCH that you've used on your, you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167.
Correct.
And in this screenshot, we can see 4 tech stream events.
Actually, can you zoom in on the key cycle?
Oh, sure.
Oh, sure.
Because I think when I got to, no, scroll. So when I got to it, you can see it was at key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So
But-
to answer your question, I got it at 1264.
So we can go back so we can see the 4 tech stream events. I just want to reestablish the foundation here. In this screenshot, we can see 4 tech stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 tech stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right. So you are aware that the Commonwealth had maintained up into your firm's engagement that.
Are you saying there's no basis for the question? All right, I'm going to allow the question and.
It's not hearsay. He
You-
looked at all
you
the
are
original
aware
data.
that the Commonwealth has maintained up until your engagement in September of 2024 that all tech stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
So the objection is sustained. You need a foundation, Mr. Lessie.
Sir, as part of your work in your review of
What are
the
you
many
reading, bro?
documents,
What are you reading?
He's not. Well, maybe he has a small screen from the big screen. That could be. We have single monitors. They never use them. Well, I've tried it in one case, but we have a monitor at every layman's podium and one at the defense and prosecution. So they'll show what's on the big screen. So
Isn't
maybe
that what's
that's it.
vertical in front of him?
It looks
the
like
mounting
then it would be
bracket
one of
to
those
a
built into the
monitor?
podium, and you can't see shit on those.
that you referenced on your direct examination. Did you review the tech stream events associated with a Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right. And did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing etc. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess' analysis of the data.
In addition to Mr. Burgess' analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the Lexus SUV had been, correct?
Correct.
Now to the question. Based upon that review, that knowledge, that understanding, those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were 2 reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents you reviewed. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir,
No, I
that there
don't.
were do you recall that there was a report of Trooper Paul?
Yes,
Okay. And you read that report, I assume, sir.
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No, I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But you did read.
He's not doing 100%. This guy is really it's dragging teeth on a cat stuck in mud.
Trooper Paul's report.
Of course.
So you therefore aware that the Commonwealth has maintained up into your engagement.
I'm going to see a sidebar on this.
What was that saying, Baker?
Pulling teeth on a cat stuck in mud.
Why are
I'm
you
just
so
every
into
time I'm
cats?
pulling teeth, everything must be cat based. I'm Danish, but
That's amazing.
and someone said trustworthy from the guy who this isn't the guy who couldn't. That was Burgess who didn't know bits from bytes.
Yeah.
But this guy, everything must be turned into an answer that actually confirms what Alessi said, but he claims that it's wrong, and then he just changed the parameter of the question. So even though he admits it, he doesn't admit it. It's stupid. We're not cruel to cats, but they are servants of Satan. Like get the blood out of stone.
1650 Salem.
I'm just saying, since we started beating cats in a barrel, I haven't seen Satan.
That's fair, I guess.
Again, the proof is in the pudding. One of the few places we don't put cats.
Oh, it's terrible.
I would hate to see the impact to Aperture's business after this trial. They are not that great.
Well, in all fairness, though, they seem to be only hired by the government, right? Like they don't really do a whole lot of defense witnessing for private defense attorneys.
Well, they did work for the defense.
He said public defenders.
When it was public defender, yeah.
Which is a government lawyer.
He does remind me of Clint Eastwood somewhat, but without acting experience. And the coolness.
Who? Brennan? Or Alessi? Or the witness?
Well, yeah, if you mean the witness, I don't see it. Oh, the fake widow is there. Talking about fake widows, fake victim has been, for those of you who know who I'm talking about, has been to trial today after she threatened to unalive a woman and her kids a few months back. And,
how'd that go?
Well, she was released on her own recognizance and has a stay away order in place and can't do anything, or she's going to the house for 90 days.
That'd be
Thank
fun.
you, Marissa. Yeah, and he's filibustering because he knows he's only hired to beef up the Commonwealth case. He knows his role, and he's doing his role, and that makes Alessi. I've seen jabs, I haven't seen hooks yet. It wasn't a trial; it was an arraignment. Well, sorry. This is what I get.
Happened. I thought that was a while ago.
Yeah, she threatened them a while ago, but she was arraigned today.
Why would the arraignment be today?
They had an arraignment right when the trial started, and that was postponed. I can't remember why. Tully gave fake victim a fake subpoena to make her a witness. Yeah, well, we don't know but we know that the good old rule is as true as ever. Never put your peen in cray-cray.
Every man's got to learn that at some point in his life.
Yep. If only Leslie was allowed to ask the necessary questions when Bev gets thirsty, he's going to be effed. Yeah, she's. I wonder, because she calls these sidebars, and this is kind of pivotal if he miscalculated the text streams. Get an arraignment when it's bumped from district to superior too. Oh, interesting.
Okay.
This guy is as slippery as a greased cat on ice.
Leave the cats alone, y'all. Jesus.
I'm almost thinking at this point, go out of order and make sure you get the important stuff in and then come back to these lines later. Yeah, it's the foundation thing, but he really needs to try and sow doubt about this text stream. Rackets actually said on Twitter, what more does he need? He got him to say that he has changed his testimony, but I think he needs to tell the jury that the text stream isn't real, because that's what Arca probably will gonna come and testify about. Cat rules, dogs rule. Oh, I like dogs.
Let's not get carried away now. Calm down.
Bev keeps asking him for more foundation. It is nuts. Yeah, but it's Bev. And that's the thing that AJ never learned at the first trial. You have to figure her out. And I think Alessi is way better at that. He knows, he'll just say, yes, Your Honor, go back and do the foundation, even though he probably thinks, I laid plenty on foundation.
Yeah, it's already there.
Yeah.
Oh.
Cats on ice. What's this? Canadian Broadway? Good one, not buying them.
That's funny. I enjoyed that. That's funny.
Well, a cat will eat you when you're dead faster than a dog. Which can be a good thing, because that'll save on burials.
May I, Your Honor?
Yes.
Thank you.
Exactly.
Are you aware that over the course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV?
So there's two words, just strike theorized.
Okay. Thank you, Your Honor. Are you aware that over the course of
As you were
the
saying.
Commonwealth's investigation and your
Hold on, Mr. Leslie. The court reporter can't hear.
Thank you. I will.
Yeah, let's get to the. Do you know they changed the time frame twice? I object again to the question that's coming.
Can I
Go ahead
begin my
and
question?
ask a
The key cycles have been represented at
appropriate
different
questions.
varying points in the evening historically. And I think Alessi's pointing that out right now.
Do
Chat.
you have knowledge whether there is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
sustained. You can ask the question, remove part of it.
I'm sorry, Your Honor.
You have to remove part of that statement.
Okay, understood, Your Honor. Do you know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustained.
I'm going to ask for an instruction.
I'm not giving the instruction now.
Dr. Welcher, in terms of the analyses that you have reviewed in this case, is there one time that you understand there to be for a hypothesis for the time of the impact at 34 Fairview?
Objection.
Objection.
I'm going to see you again, folks. I'm sorry about this.
He read the report. He stated that he read Trooper Paul's report. Trooper Paul's report mentions at 12:45 is when the impact occurred. Read at 11:62 in the key strokes. He should be able to answer this and say, no, I read it, but I disagreed with it. But this will be very, very important to try and get in front of the jury, unless he is asking it really badly. I don't know if... What time is it? Yeah, you can't even ask if it would be a good time to go and break, and then they could go back and put their heads together and say, how the F are we getting this in? So I don't know how to formulate the question better, but it is based on Trooper Paul's report. The impact happened at 12:45. He read the keystroke and made that determination. Now this guy says, no, it happened at 12:32. So how could Trooper Paul, who is an expert, who has been trained as an accident reconstructionist, have a different time reading the exact same raw data like this guy? Who was wrong? Was it Trooper Paul or was it this guy? This is what he want to put in front of the jury and have the jury think about another thing that doesn't mismatch. But he can't really crack the code of how to ask the question. It gets very convoluted the way he asks it. I'm dumb in more than 3 languages, sir. No, Kimmy. And Dr. Welcher isn't smart enough to work for ACA. That's why he works for $700 an hour as a senior VP at a company that has to sponsor bar events for the Massachusetts State Bar to try and drum up some business. They've just been taken over by a private equity company that, of course, will try and make them make as much money. And he's been good at that because the Commonwealth has paid them $325,000 to do a job that is on a scale from piss poor to really piss poor, is somewhere in between. But you, girl, you're doing a great job. Okay, Baker, how should it be asked? I can't tell you how it should be asked because I don't know how to formulate it. But it's convoluted the way he goes back and uses double negatives. And hey, I'm a baker. I'm not an $1,800 an hour lawyer. I know where he's going, but I can't tell you how to get there. I'm willing to keep an open mind, but he should have appeared on Thursday. Good of Bev to allow them 5 days. I don't know. It really baffled me how John's family doesn't mind all this. They're buying into it. I hate to say it, but they're hoping on the big payday will come in civil court after. Because it's not like Peg and John was good friends when he died. I'm smart, dumb. That's something my high school boyfriend used to chant. Do you recall reading the trooper's report? Do you recall when trooper said at what time that? Yeah, you could do it that way. You testified that you read Trooper Paul's report. Yes. Do you remember at what time he claimed the incident occurred? No. Would reading the report refresh your memory? Yes. After reading the report, at what time did Trooper Paul believe that this incident occurred? 12:45. You claim that this happened somewhere between 12:30 and 12:32. Can you tell us why there's 15 minutes discrepancies on your timelines? Probably could get it that way. You ain't no virgin. Where's how dad? Okay. Yeah, he's he needs, but I think he's trying to complicate his own. He needs to dumb it down, really slow it down, and get down, and then move slowly forward. I don't know if Wednesdays are his bad day. Remember, not last Wednesday, previous Wednesday, where he was talking to. Was it then? There was a Wednesday where he was asking someone. No, that was it Friday. I can't remember. But then they went on a break, and then he came back, and he had slowed it way down, and then boom, 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 boom. Everything was just running. Maybe he hyped himself too much this morning or something. Kind of like, when boxers go into the ring and they need to get punched a few times in the face to kind of relax and start fighting. Believe the lie is also a defense. It is. It's easier to claim Karen did it than see reality. Well, it's because they wanted to test it. So, with all the bald men in Canton and Norfolk County, I wonder if they can be seen from outer space. Probably. Yeah, he needs to slow it down. Slow it way down. Who's the homely chick in blue? I can't remember all these.
I don't remember.
It's not
who
John's
she is
wife.
either. She's there a lot, though.
We get asked about her all the time. It's not one of the Sullivan sisters.
No, because we thought it was for a long time.
Yeah, it's He said that he didn't know how fast the car was going when he hit John. He doesn't know when or how or at what speed John was hit. He just say it's consistent with being hit, which if you leave out the how, when, and where, and then claim, well, it's proven because he ended up on the lawn. That's not really proven.
What did I miss? Did we
like 37 sidebars?
We since you've been gone, we have gotten into. I really don't want to answer a question, so I'm going to ask a counter question, and then I'm going to reformulate your question to the opposite, and then I'm going to answer that no. Even though that means I actually answered your question yes, and when you keep asking me about it, I'm going to find a new way to not answer it. I don't like that hairstyle on Miss Little.
And I'm not a fan.
It looks like it's unkempt, unwashed. She's normally a very pretty woman.
It looks like a fee mullet.
Yeah.
It's a fee mullet. I cannot abide Miss.
Is it
Little
Officer
style.
Carl's wife? It could be.
Yeah, Your Honor?
Yes.
Thank you.
Yeah, those should be the questions
I'm going
answered.
to move to, for the moment, we'll come back to the other topic a little bit later. As we discussed earlier, you've got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is
Sure.
is biomechanical engineer something you consider yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And the CV and resume I gave you.
Right. Now, in your report, and Your Honor,
Oh God, is
I
he
have no
pending
issue if he
too?
refers to the
Thank you.
page of his report.
Do you have a paper copy or do you need your?
I do.
If you, sir, could turn to
Pursuing.
page 9 of
Pursuing.
your
Oh,
report.
I'm sorry. I too am in pursuit of day drinking. What-
And on
Stop touching the
page 9,
microphone, Alessi.
you state, as a biomechanical engineer, I have no opinion on any aspect of, and I think you're referring to Mr. O'Keefe's, medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
Did?
In
Then
that
why are you opining on
statement,
injuries?
I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes.
And you go on to add on page 9, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. Did I read that correct?
You did?
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge as you would assess the cables and beams of a bridge, you assess the human anatomy. You made that analogy, correct?
The analogy that bones are my bridge elements, cables
Oh
are
God, not
muscles
his
and ligaments.
bones again.
Right. And you stated that it's the job of a biomechanical engineer to quantify the force acting upon a person to determine the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something that a biomechanical engineer does, correct?
If given sufficient data, yes.
So you know do you know what a force calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I wanted to get to. Newton's second law is, and sometimes referred to as the second law of motion. And in the second law is force equals mass times acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine.
Is
sir,
he
you're
getting
pulling-
his
Why,
phone out?
why is he pulling up
What
his
the hell is
calculator now?
this? I
Bev, you
cannot
have
with
to
this
tell
man.
this witness to stop
What is he doing?
concentrating about anything else than answering these effing questions. You can find him for being in contempt of court. He has now 3 times been told,
Dealing with stuff.
told not to do it. And now he's pulling out his calculator. He can't answer a simple question unless it's what's your name? Well, I used to be, but today I go by. Really, my first name isn't Judd. It is Judy, but I
No, it's
skipped the
Judson
Y.
with 2 D's.
Just like it's spelled. And Welshire, like the real thing.
something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right, we need to do, if we're gonna do that, we need to do it with the court's permission. So
Sorry.
if you feel you need to do that.
Again, this guy claims on his
He's been
own website he
an
has
expert.
1,000 cases at least under his belt. Fine his ass for being in
Okay.
contempt of court.
I do have a question before we start again. Has Alessi been doing well? Is he,
No.
or is this? I hope
He's
Okay.
constantly slipping around every asked question. He's not getting anything yes or no out of him.
I almost wonder if he expected to not be on cross until after lunch. I almost wonder if that's what the problem is.
Yeah.
Well,
That
all
just
the
let me,
witnesses have been slippery. So
No,
I've
this guy
noticed this
is
with-
specifically, he's turning, unless if he asks, did you go to A? He will say, when you claim I went to B, I didn't do that. I went to A.
Yeah.
But I didn't claim
So-
you went to B. I asked you if you went to A. Your assertion that I ever went to B is incorrect. I went to A. This
So
has been
painful. It's
been
Oh,
an
good.
hour
Well,
of this.
you guys were feeling the pain with me as I was trying to get Mr. Mo to wear earbuds. He's like, "No, I'm going to put in the speakers for the Zoom call." I said, "You cannot do this." "Yes, I can." "Why is there an echo?" "You have
'Cause
to
you
use
got
the
speakers.
earbuds."
And unless he slipped up on dates in the beginning, unless he seems off his game today.
Well,
does.
I've noticed with Alessi, he has to study people to see how they get around his questions. And once he figures out what they're using, he usually does better. But this is almost like a testing thing for him, too, to see how this witness is doing this. And I wonder if he's going to get some talk from the other lawyers during lunch about maybe
Yeah.
suggestions.
Get your head on.
You can just leave it right
All
there.
right.
So I just want to get the principles down first. So Newton's second law, force equals mass times acceleration, and force is oftentimes what you're trying to calculate in a force calculation, correct? Using-
Calculate or measure, yes.
Yeah. And Newton's first law is the law of generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that in force. We're talking about Newton's just second law, correct?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
Okay.
See, so he's agreeing with him, but he has to tell you why he's agreeing.
In that, Newton's second law is generally just a mathematical calculation, correct?
Yes.
So what I'd like to do is to turn to page 11 of your report.
Oh, did he screw up the math? Look, I'm not going to know, but Alessi's going to know.
I hope he is.
Put
Did he
your
put- he-
calculator down, you butt monkey.
Nope.
That's it. Someone tie his
And
hands
on
together.
page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you dropped a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches, at that fall, Mr. O'Keefe's head would have accelerated with 458 G's of force.
That's what we actually measured.
Right.
In the test.
And can you tell the jury what is
G's?
meant by G's?
So G's is a measure of acceleration. If you use the acceleration
Fast.
measured in feet per second squared,
That's crazy
divide it
fast.
by 1G, which is 32.174 feet per
Don't you
second
only go to
squared.
4Gs?
That gives it to you in
Mach
Gs.
4?
People often
Or is
heard
that
about
10
fighter
Gs?
pilots losing consciousness at 6 or 7
No, it's
Gs.
a G is
It's 'cause
Mach,
your
I
blood-
think.
A G is the turn or the
Oh.
force when you get.
Y'all, I just had to listen to math about stocks and crap I don't understand. Today is trying to kill me. Sorry.
Blood's getting
Personal
sucked
aside.
away from your head, not because you're being impacted. But G forces, or Gs as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately
There
15.7
you go,
pounds.
Zach.
You used a percentage. Is 15.7 about right for the mass of
Yes.
the head? So if we apply Newton's second law, we keep F force open as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
Jeez.
In that 7,200 pounds is the previous unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds.
Now he's probably going to do exactly the same because you have you can measure the force because you have the speed of the car, you have the mass of the car, so F will be a force acted upon his skull when it hit him.
Now you then go on to note that the
Well, we know the
applicable
mass, so we could
scientific
find out the speed,
literature
if that's the
states
case.
that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand it, you go to scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry.
How many inches?
40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds. And then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No. 1,634.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And you compare that to the 7,200 pounds of force that you calculated, surely you're going to have a fracture of the occipital bones through that calculation in that comparison, correct?
Correct. Falling on a hard surface can definitely fracture
Right.
your skull.
So,
He's going to say the
so
car hitting him in the face now. That's where he's going.
I'm not getting at the manner. I'm just applying the Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface. The A value is a function of the surface you hit.
That's not in Newton's
So you're
law.
saying acceleration depends upon the surface?
Yes, of course.
Okay, all right.
For an impact, it does.
Now, let's go to the study you
He's
cited.
simply using Newton's law. He's
Injuries
not
to
doing
pedestrians in
impact,
real
you idiot.
accidents in their relation to collision and car characteristics. That's in your report, correct?
What reference number?
May I, Your Honor, grab the report?
Yes.
It's in your report, sir. If you can find it, I'll do it in parallel.
What he actually should have said is, I measured the force that he would have impacted on the surface, and then yes, we can then extrapolate from what type of surface. Because it's not acceleration isn't what type of surface you hit, it's what force you apply when you hit a surface.
Yeah, it's not surface dependent. You can accelerate into a bag of marshmallows or a sandbag. You're still going to have some sort of force. Now, the different resistance you
25.
face.
That's the one I think it is. I just want to check your report.
Would you like me to actually pull up the paper?
No,
Okay.
No,
just want to get to the. That's it. Number 25. We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Or could the witness see the document being referred
Do you have your?
He has it in his hand,
I
you
have my
idiot.
report, but reference 25 is not in the section he's referring to.
What?
Oh, for fuck's sake.
Why don't you show it to him, Mr. Leslie?
I do not have with me a copy of the report he cites in his reference. He did. Can I ask another question? Your Honor?
Yes.
Thank you. Dr. Welcher, on your direct testimony, did you not discuss the percentage of pedestrian injuries and relate it to heads? Did you not on your direct talk
We saw
about
that yesterday on a
percentages
slide.
of injuries that are head injuries in impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next
Can I
question.
go to my slide?
Whatever you can use to determine what was the percentage that's in the study that you cite in footnote 25 of your report.
Sure. That was also from my presentation that I gave. It's 61.5 for all injuries, 12.7 for fatal injuries.
Thank you.
You're
So I'll
welcome.
repeat my question and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
Nope.
It's circled with a red box.
You didn't mention
on my
it.
Slide.
Did you mention that on your testimony
I
on direct?
thought I did.
No, you didn't.
No, that's why he's asking you the
This
question.
article was published back in 1979, correct?
I believe that's correct.
It's 46 years old, therefore, if I did the math correct, right?
That sounds correct.
Do
Are
need to
you
calculate
aware
it?
that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. It wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or bounce off, to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you,
He just
saw
said
him-
that he just said that typically a head injury is caused from slamming into the hood or window.
Yeah, it's a hard impact that causes it when you hit the car, not when you hit the ground after.
So when
That's
the
what he
car
also
hits your
said.
arm,
That's why he didn't
you're
say
gonna
it
smack the
yesterday.
head.
That's why
this
he
dude
didn't.
is so full of shit.
But he did say
also
that the head was
referenced a
hit by
paper
the
from
spoiler. Remember that?
1979.
Yeah.
And
Who
again,
referenced-
he has a video out there. You can see it on Twitter where he is reconstructing a car strike on a crash test dummy, where he states that the propensity of injuries happens to the lower extremities. So what he did yesterday was just say, well, there's no new literature, and I need to prove that it hit the head. You pay me enough, I'll say what you want. Allegedly in Minecraft, I don't know if that's the real thing.
I'll use the study from
You would agree.
1979 instead.
that as of January 2022, the most common injury as a result of a pedestrian motor vehicle collision is one to lower extremities.
Why does he need to put down the
No,
date?
I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
So you
Why? Because you didn't put a rear in your chalk. You put a frontal. So I can't with this guy.
contest that the most commonly understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities.
So I'll allow the question.
So I'd want to see the data. Again, most cars, for example, this Lexus has a pre-collision system in it that will start to apply the brakes if it senses a pedestrian at the front of the car. And so for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries. So the change in the technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
I'll try it a
He's
different
not
way.
answering the damn question.
No,
You have
and this
not-
is 2
You
hours.
sit here today.
Oh my gosh,
whole
you guys, what are
time.
you saying?
Whether the most common injury from a motor vehicle accident is to the lower extremities.
I'd have to look at the literature. I have the article I gave you.
So the answer is you don't know the answer to that question. Is that correct, sir?
I don't know it off the top of my head.
All right.
You're an expert,
The
you
f-
say?
Newton's second law analysis that we went through, force equals mass times acceleration, where
Do
we
not get
came
your
up
calculator,
with
you butt
the
monkey.
7,200 number. You didn't discuss that calculation on your direct examination, did you?
I don't think so. We didn't discuss a whole bunch of those things that were that wasn't necessarily an opinion. That was a sub-opinion or basis for my opinion.
You didn't discuss that Newton law calculation on your direct examination, did you, sir?
So in a way I did, because I said my drop testing shows that you
Oh,
can do
this guy is
this.
dumber
So I
than
didn't
the
quote
trolls
that
I have
number,
in my
but
chat.
We are
This
going
is,
through the
I would rather
specific
talk to
numbers
Previn.
now, but I absolutely
Kimmy,
did say,
come
as
back.
a matter of fact, I showed a
Kimmy is here.
video
Kind of fool.
of my
Could
drop
see
testing
I
and
was
talked about
wrong.
how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no.
Thank
The general
you.
concept of the drop testing and what it showed, yes.
So instead of that calculation, you referred to a flow chart comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not instead of. They're two completely different topics. So no, I didn't do that instead of.
Okay.
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury is associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
Let's ask it this way. Did you, on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M and 458 for the G to come up with 7,200? Was that anywhere on your slide presentation?
So the slide presentation showed the 458 Gs. The rest of it was not on there.
Thank you.
You're welcome.
You also indicated that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV.
Get to
Do you
it now.
recall that?
Correct. It's actually properly called a spoiler.
And
Oh,
so you would
whatever.
call it a spoiler instead of a fin?
Correct.
Yes,
Fair enough. We'll
Because-
call it a
Dude.
spoiler.
that is what it is.
Well,
You visited the
still,
scene at 34
pedantic
Fairview,
douche.
correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I'd use the word like, but we want to go to the scene to see the scene.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No, I actually didn't set foot on the property.
You didn't set foot on the property.
No, I stayed in the street. It's my understanding there were new owners.
Yeah, there were.
Did you consider the scene limited to the road?
So the access I had was to the road. The laser scanners and the photographs will extend further, but I didn't have access to the interior of the house.
Oh, so you didn't access the entire scene, correct?
In my opinion, I did access the entire scene.
But he was found
I
on the
didn't
ground.
physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I didn't want to trespass.
Where did you understand the body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen cruiser cameras showing people around a body. It's slightly north and slightly south and a little bit west of the flagpole.
But you didn't access that part of the scene that you just described,
Wait,
correct?
I
what?
absolutely
No.
did. I took photographs of it. I didn't trespass and stand at that exact location, but I stood right there. We scanned the whole thing. The scanner uses a laser beam
South
that
and
goes
east.
out, 150, 200, 300 feet. So we scanned all that stuff.
Did your scan topography?
Yes,
Then you know that there is a berm raised above street level, correct? If you did the scan.
correct.
Do you know the height of that berm?
I believe it's 4 inches.
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know exactly where the point of impact is, whether he was completely in the road
So you should have two calculations.
or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will
So
be
she
at the
hit the
height of the
curb now?
curb. So if
now
he's
we
standing
are speculating
on
her-
the higher part and the right rear tire of the
Baker.
Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact.
I need to get some Yoda
So
energy.
I don't know whether he was on the road or in the street. Excuse me, on the street or on the side of the road.
Exactly, but when you did your depiction on your slide, and you remember you had the ruler and you measured the height, you did all
Absolutely.
that?
Yep,
Where was it? It was you? Was it you in that slide?
it was
Where were your feet?
on the ground.
Not on the berm, correct?
Correct.
Okay, so you chose a measurement, which was the ground to the top toward the spoiler, and you took a measurement. And you said that that approximates the height of Mr. O'Keefe, correct?
Of the laceration of Mr. O'Keefe.
Exactly, because what you were doing was you were trying to determine and present testimony on whether or not that laceration could be caused by the spoiler, and to do so, you had to take measurements, correct?
Correct.
So, you chose to place Mr. O'Keefe in your simulation on the ground. You didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't do
Correct.
either one of those.
So, the point is, it's certainly
Confirmation
possible that if
bias.
there's 4 to 5 more inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head.
Then
So
how
how-
can you make anything of this?
You testified to an engineering certainty. This is what had happened was. And now you say, well, it was what had happened was, but he could also have been doing this or doing this or doing that or doing. Which means you don't have an engineering type of. This is so fucking stupid.
Well, he could have also, ridden away on Falcor. We never know. Maybe Falcor the Wish Dragon was there to help him. Good God Almighty.
describe the possibility that his head could be down. You're, as I understand it, you're positioned in that photo just like this. You're not positioned like that in any photo you presented to the jury, were you?
I'm trying to make it clear. We don't know his exact body position at the point of impact, nor do we know the exact position on the ground. So, which is part of the reason why I haven't tried to exactly simulate this, because we don't have enough parameters to do that. So I don't have that information. I'm showing the geometry relative to someone of Mr. O'Keefe's height.
So you don't have the information to do that
Yeah, we don't know is the quote of the day. Yes, thank you, Stacey.
properly, so therefore you can't conclude that he had a laceration to the eye from the spoiler by your own answer that you just gave, correct?
So it was done properly. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height, matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede that the level of his eye could be non-contacting that fin or spoiler, because you don't have information as you just described.
Sure, it could be from contacting the ground.
Pardon me?
It could be from contacting the ground. It could be from other
No,
things.
because he fell on the back of his
You
head.
don't have the information necessary to conclude with any certainty that Mr. O'Keefe at the time of impact had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
And you didn't take into consideration the berm, and you didn't mention the berm at all when you were discussing this measurement with the jury yesterday, correct?
That is not correct. You asked me two questions. I absolutely considered the berm. And the second question when I presented to the jury, I mentioned the berm when we showed the picture of the shoe in the snow, but that was it.
That's my question. I'll ask it a different way. When we were talking not about finding a shoe in the snow, and you mentioned a
We
berm,
were looking forward to
talking
this.
about when you did the measurement of whether or not the laceration could be caused by the spoiler, you didn't mention accounting for berm height when you discussed that measurement with the jury, did you?
That is correct.
Why couldn't you just say yes before?
Because he's a giant douche canoe of
Likewise.
epic proportion.
You didn't present any Newton's second law analysis regarding the front of Mr. O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh,
Of course
so
you are.
It's a glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
So
But his
you
head would
can
have been-
your arm to the side like this, with the back of the vehicle coming like this, and you could glance the right eye with the arm out. Is that what you're saying?
That's what my picture shows when I'm standing next to the car.
No, it's not. No, it's absolutely
you're,
not.
You're leaning in.
I could probably
You're
find the
leaning
slide for
in.
you.
So
No,
you
we don't need
didn't
your
do a force analysis to determine how much force would be applied assuming a contact.
I haven't tried to exactly reconstruct it. Yeah, this is the problem. And again, if his arm is here, his head must be here. So that would get the full brunt of the car in his face.
Hey, Baker, if they don't know how any of this happened, is that reasonable doubt?
No,
When
no, no,
you're
no, because
guesstimating?
he just didn't do all the calculations between Karen Reed was driving a car and John O'Keefe died. But you can trust him. That's how it happened. He had
You
blue
know, I
paint on
never-
his arm, Mo blue paint.
I never thought I would wish for Trooper Paul's math and stuff. It feels more honest.
He actually tried to make science fit. This guy just said, "Yeah, I didn't look at it. Yeah, it works." How?
He had
I have a slide.
900, but yeah, he had so much text on his slides. He could have added all of this, but he's like, no, I mean, I did. I talked about the berm with the shoe. Sir, Aperture is not going to be a company after a couple months.
with the right eye, did you?
That's correct.
And force analysis is what biomechanists do, correct? That's what a biomechanist does?
That is part of what we
Part of
do.
what they do.
So I lined up his anthropometry relative to the known height of the vehicle.
You attempted to line it up. That's one method, but another method is to apply Newton's second law like you did to the back of the head when he fell, correct?
Correct, if we had more information.
But you know the injuries to his face.
What other information would you
So, Leslie,
need?
why don't we break here?
Thank you,
Oh
Your
my
Honor.
gosh.
Oh, we're getting a long break today.
Ooh, 150. Woohoo.
This is actually it started rough because this guy can't answer an effing question.
It hurts. It hurts my head.
So he either isn't listening or he is willfully being absolutely obstreperous.
It's that one.
Whatever this last one is, I'll have two.
Yeah.
Oh, yeah. I think the red Solo cup is coming out for afternoon. I'm just saying, y'all. It's like I'm not one to promote day drinking outside of a jest, but they're bringing math into this, and no. I
don't understand why he's so incapable of that formula, right? Like Newton's second law, mass times force or mass times acceleration equals force. We know the mass of the vehicle. You have the acceleration from the tech stream. At some point in there should be a range of force applicable, whether he was hit at point A or point B. You can do the mathematics. I can't because I'm not that smart, but
Okay.
somebody can.
wouldn't 400 G's have his head, no disrespect,
Explode
but
like
like
a watermelon?
exploding like a Gallagher watermelon? I mean,
I would think so. That's a lot of force, y'all. That's a whole lot of
400 G's is a little much.
Is it a little much?
from a 60-inch drop, I mean, I could understand, again, enough. We've seen enough falls, we've been around enough people to realize that, yes, you can injure your head from, just your standing height. How do you mathology everything when you were like, oh, we don't know where he hit and we don't know what we did and I hate this man so
How did he
much.
get clipped in the head with the spoiler? I might have over-exaggerated the angle, but he would be hit by the tail light and spun because it's a glancing blow.
Well, and
So
doesn't
how
the
does
roof
his head-
taper in? Like but like trapezoidal kind of, it tapers in usually. So he'd have to be leaning more over to tie his shoe, hold his glass. Who the hell knows?
It's probably more like that on an SUV. But
Yeah.
he would have had to have been hit, bent in that direction, smacked his head against the spoiler to make this theory make sense. But then you would also have hit every single part below the head, because every part below the head spoiler protrudes over the spoiler on a standard SUV. So everything from the knees to the head would have been hit if he slams his head against the spoiler. The spoiler doesn't protrude over the car. Go in the lunch break, go out and try and stand next to your car, no matter how big or tall or small you are, and put your right eye at the spoiler, which is, it's also, it's doing this.
Yeah, it's trapezoidal. Also, did he get to the blue body paint when I was gone?
No, we haven't
No.
talked about the blue button.
Oh,
haven't got
thank
there
you.
yet.
That was the one thing I didn't want to miss.
There was no DNA found on the spoiler. I don't believe they swabbed it either. Let's see where
No, and wouldn't you have an orbital bone fracture? Again, even if these are glancing blows, if someone glancingly hits you, you can get an orbital fracture. I mean,
He has an
glancing
orbital
blow-
fracture, but nowhere severe enough to account for what would have happened.
Also, state of Massachusetts, I can be an expert too. Give me 400K and I'll do whatever you want. I mean, I'll feel bad about myself, but I'll do it.
Hey, I'll do anything for money.
Anything?
You know
So wait,
that.
so the state of Massachusetts is in how many K for this case alone? You've got Brennan, who is 400. You've got the
At
experts who are
least
400.
600,000 on just Arca and Brenner alone.
Not
So
Arca.
let's
Arca.
Aperture. So let's make it a cool
Why does it look like
150.
he's fisting the car?
Well, it's because I put in the tail light. This is what he claims the position was. He has his arm bent and gets hit by the tail light. Then how is he getting hit in his right eye? Then he would have to have his head leaned forward. If he leans his head forward so it's aligned with the spoiler, I'll show you a magic trick.
Ooh, magic.
Flux. What's up, Flux?
He would have been.
Flux.
He would have had to have had his upper body crushed by the car when it hit him because he would be leaning forward.
Yeah, he would have had rib
In the arm and the
fractures.
eye at the same time, unless he's getting hit everywhere below the neck as well. And his face is going to get trashed. This, I hope they have a chalk that they can show. Because this is redunculous.
What
This dude
I
hurts
do,
my head.
yeah, what I do say as a person who is not comfortable with numbers, unless Alessi can go very middle school / elementary school math when he's explaining this and kind of getting it, because they're both comfortable with this, whereas the jurors might not be, and so they are all confused. I hope that he can
They need
get
a
to-
whiteboard to show them that it
Yeah.
just doesn't make sense that you can stand like this up straight and then you still get hit in a position like this. But if you get hit in the position, my shoulders continues. It's not like I can just elongate my neck and put it forward. I wish I could so I could look around corners, but I can't. I'll have to bend at the waist and then I'll get hit. And if I get hit here by the spoiler, all of this will protrude and get slammed into by at least this part of my head would be crushed by the rear window on the car. But
It
the
also
solution
changes
to our
your
head
center of
pain is in my
gravity.
pick text. I can't see your pick text, and I don't dare. And Volpe, anything? Anything what?
I think, did anything happen yet?
Oh yeah, that's a lot happening. Me losing my temper.
This is crazy. 450 G's of force is what he's saying, but no bruising or anything.
No bruising, no internal injuries.
Well, he had that scrape on the back of the head that came because he had a hat
From the
on.
hat.
Yeah.
From the hat.
So that's where the J came from, the hat?
Apparently.
No. We don't talk about the J. We're talking about
Oh,
that abrasion that is kind of pulled up is because he had his hat on, and then when that slid on the ground,
Yikes.
even though he fell straight back, he also had a scraping injury when his body moved,
moved
falling
on
flat
ground that was
backwards
supposed to
and
be
had a forward motion.
frozen, so the chlorophyll and the mud wouldn't be on his pants, because if it's actually permanently frozen, hard concrete, you're not going to have those transfers.
Yeah, I think when they hit a wall in Formula One, they hit like 30 or 40 Gs. This is 10 times as much. I think 35 Gs is what snapped the neck of Ayrton Senna. That's why they have the neck guards on now, because you can't hold your head at these forces.
He's also
Let's
so
just-
condescending.
Yeah, he's condescending and he's a big old liar. And again, with a whiteboard, I can prove this couldn't have happened in the way he states. And he just says, well, you have to trust me because I kind of maybe have looked at something kind of.
So a quick, enough of your Formula One nonsense for us Americans in NASCAR, where raise hail, praise Dale. He apparently hit the wall with 68 to 48 G forces,
Holy goodness.
which is equivalent to dropping the car face first from 60 feet in the air onto a slab of concrete.
But it's only a tenth of what it gives you to fall backwards if you're 6'2".
Something like that, yeah, give or take.
Thank goodness
math
I
ain't
always fall
mathin'.
forward.
Got built-in airbags. You're good.
Yeah.
We'll be back in 30 minutes. I need some dinner.
Bye, you guys.
Yes, I did examine his lower extremities. That is protocol in any case of suspected impact with a motor vehicle. So I did examine his legs and I did not see any evidence of an impact site.
Just pin it on the girl, right?